I beg to mention item number 17. I'm appearing for the petitioner. The learned conducting counsel of this case is unwell, so matter may be adjourned today. Please, after a week.
Mr. What is your name?
N. Talin.
Learned counsel for the petitioner. Praise for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner.
Interim is there, it may be
considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after a week. The interim order shall continue till next day.
Obliged.
May I, my lord? My lord, item number 13, my lord. I am on behalf of Mr. Titi Tara, my lord. Petitioner, side
30.
13, 1,
1
3.
3. Yes.
This matter may be listed in the month November 1st week, my lord.
Why?
That will be convenient for both the parties. Opposite parties also.
You have informed the other side.
Yes, yes.
Mr. What is your name?
T. Kamchi. On behalf of Titi Tara, my lord.
Learned counsel for the petitioner, who prays for an adjournment with the consent of learned counsel for the respondent side on the ground of personal difficulties. Considering the ground the prayer is allowed, let this matter be listed after 6 weeks. On a date to be fixed by the registrar.
Interim order is there.
Then when you are enjoying interim, you cannot have such a long adjournment. 4 weeks, interim order shall continue.
4 weeks, my lord. Interim order may continue.
Interim order shall continue.
Another item is there. Item number 19, my lord.
Yes.
This item may be fixed.
You have informed the other side.
Yes.
Heard. Mr.
T. Kamchi.
T. Kamchi, learned counsel for the appellant, also heard Miss D. Tamuk, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty, to which the respondent side does not raise an objection. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed on 4th of September.
Interim order is also there.
Interim order is there.
Yes, sir.
The interim order shall continue till next day.
Much obliged.
My lord, I beg to mention item number 20. Conducting counsel for the petitioner, Mr. R. Sonar, he couldn't make his presence before his honorable court due to some personal difficulty. I have taken the consent also.
Mr.
M. Khambo.
Khambo, learned counsel, submitting on behalf of Mr. R. Sonar, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed.
4 weeks. 4 weeks time may be given.
4 weeks.
Yes.
The date to be fixed by registrar.
Okay. Okay.
May I, Lordship? Lordship, I beg to mention item number 10.
Yes.
Lordship, in this matter, we have supposed to take step. However, inadvertently, we couldn't take the step on time. So we may be allowed to.
For issuance of notice.
Yes, Your Lordship.
Steps for? What steps? For issuance of
For
notice
respondent
to
number
respondent
2.
number
Upon respondent number 2.
Okay.
Your Lordship.
Heard Miss
N. Hondi.
learned counsel for the appellant, who submits that the appellant may be allowed some more time to take steps for issuance of notice on respondent number 2. Considering the prayer, the Considering the submissions, the prayer is allowed. We let this matter be listed again after
2 weeks,
2
Lordship.
weeks. In the meanwhile, the appellant shall take steps as directed earlier. Stop.
Within 2 days, we'll take step.
Okay, within 2 days.
Lordship, I'm mentioning item number 22. Conducting counsel, leading counsel, Mr. B. Zamo is out of station. So 3 weeks of time may be given, Lordship.
Who is out of station?
B. Zamo. BJ
B.
Zamo.
Jammu.
Yes, Lordship.
Heard, Mr. What is your name? What is your name?
Conducting counsel, B. Zamo is not ready today, Lordship.
He,
Keado.
and counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appeal. For the respondent, V. Jammu is for.
Not ready today. Is not ready
V.
today.
Jammu is for whom?
Respondent number 2.
Respondent number 2. You have informed the appellant's counsel.
Yes, Lordship.
He submits that he has already informed the counsel for the appellant regarding his prayer for adjournment. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Bless, Lordship.
My place, Lordship.
What is this?
Challenge the bail cancellation order
Yes, my lord. My lord,
Bail was cancelled.
by the learned session court, your lordship.
Okay.
Bail,
in revision, therefore I am before your lordship. Learned session court cannot cancel the bail, my lord, in revision, my lord, because this is the interlocutory order. Bail, granting of bail and rejection of bail. It is in interlocutory order, therefore no revision can lie. This is my ground, my lord. The fact of the case is that, my lord, on 14/1/2020, a missing report was filed by one Chandra Tanti. He stated that his son
Oh, just,
is missing.
you have filed this petition under what provision?
My lord, under 482, my lord.
Whether 482 lies against.
Yes, my lord.
Okay, please
Uh,
continue.
My lord, there was a missing report filed by one Chandra Tanti. And that missing report, my lord, it was taken up by Customs PS as case number 2 of 2020. And after investigation, my lord, the Customs PS has registered a case, my lord, which is number is 2 of 2020 under section 363, 120B and 370 IPC, my lord. Hereafter, my lord,
Which police station?
Karsang PS,
Carson,
yes, under Changlang district, my
Changlang
lord.
district.
Hereafter, my lord, the petitioner, who is the alleged accused in that particular case, my lord, has applied for this bail, my lord. Before although, my lord, he is the executive magistrate, my lord, since in that locality, that area, my lord, judicial magistrate has been posted, my lord. But during that point of time, he was on leave, and therefore the executive magistrate, he was given the charge, my lord. And while functioning as judicial magistrate, my lord, the petitioner, he was given bail, my lord, by the magistrate, my lord.
Executive magistrate gave the bail.
Yes, my lord. But since, my lord, there was no judicial magistrate, he was on leave, my lord, at that point of time.
Then who remains on charge, in
Charge,
charge?
the executive magistrate, my lord, who is given the bail.
Under what provision?
That, my lord, there is a notification of government of Arunachal Pradesh, my lord. In the absence of judicial magistrate, my lord, executive magistrate can be given the charge, my lord.
No. Who gives the charge?
Charge, my lord, the incumbent, my lord, who was regular judicial magistrate, my lord, but he was on leave. So therefore, this executive magistrate was given the charge, my lord.
Who gave the charge?
The JMFC, my lord,
No,
judicial magistrate, my lord.
as I just want to understand. Judicial magistrate goes on leave. His leave has to be granted by some authority, either district judge or CJM. Judicial magistrate is under the administrative control of either CJM or district
That
judge.
fairly, my lord, I am submitting, I do not have idea, but the trend is that, my lord, whenever
No,
the.
I just want to understand the
Yes.
law. Because who will remain in charge? That person who granted leave, the authority which granted leave will state as to who will
Yes,
retain.
my lord, in this case, my lord,
Judicial magistrate cannot go on leave on his own.
yes, my lord.
He has to seek leave from his superior authority.
yes, ma'am.
Either he has to be chief judicial magistrate or district judge.
Oh, yes, my lord, yes, my lord.
So district judge or CJM will say who will remain in charge in his absence.
Your lordship may find in section 167 of the CRPC as well, your lordship, the executive magistrate, the limited power has been granted to, has given to the executive magistrate for remand.
No bail.
Under 167 2A, your lordship, of CRPC.
CRPC.
Yes, your lordship.
Oh.
167,
2A, your lordship, subsection 2 capital A.
yes,
May I read it?
yes.
Notwithstanding anything contained in subsection 1 or subsection 2, the officer in charge of the police station or the police officer making investigation, if he is not below the rank of sub-inspector, may, where a judicial magistrate is not available, transmit to the nearest executive magistrate on whom the power of a judicial magistrate or metropolitan magistrate have been conferred a copy of the entry of the diary hereinafter prescribed relating to the case, and shall at the same time forward the accused to the executive magistrate, and thereupon such executive magistrate may, for the reason to be recorded in writing, authorize the detention of the accused person in such custody as he may think fit for a term not exceeding 7 days in aggregate, and on the expiry of the period of detention so authorized, the accused person shall be released on bail except where an order for further detention of an accused has been made by the magistrate competent to make such order. And where no order for such further detention is made, the period during which the accused was detained in custody under order made by the executive magistrate under this subsection shall be taken into account in computing the period specified in para A of the proviso of subsection 2. Provided that before the expiry of the period aforesaid, the executive magistrate shall transmit to the nearest judicial magistrate to the record of the case together with a copy of entries in the diary relating to the case which was transmitted to him by officer in charge of police station or the officer making the investigation as case may be, your lordship.
So where a judicial magistrate is not available.
Not available.
The executive magistrate has power to remand.
Yes, limited power, your lordship, for only 7 days, your lordship.
And whether he has got power to grant bail.
Yeah, that is the issue, your lordship, here, your lordship. If remand, your lordship, the question here is if he has a power to remand, then he has, the remand cannot be given, your lordship, mechanically, your lordship. This is well settled. I'm I'm confined to that, your lordship. Remand cannot be given mechanically, so therefore, your lordship, perhaps in my humble understanding, your lordship, if we understand in that extent, then magistrate can grant bail.
When judiciary was separated from executive in Arunachal Pradesh, in which year?
In the year 2013, my lord.
13.
Yes,
Before this notification came into force.
yes, my lord.
Okay, okay, continue.
Now, my lord, as I have submitted, my lord. The present petitioner, my lord, he was granted bail on 11/3/2020, my lord, by the executive magistrate, my lord, although he was functioning as judicial magistrate at that very particular point of time. So, as per 167A, and coupled with the notification of the state government, my lord, the executive magistrate has the
Whether,
power
whether
to.
this notification is still in force?
Yes, my lord.
Okay.
Now, thereafter, my lord, after I was granted bail, my lord, the petitioner was granted bail, my lord, on 12/3, my lord, on the next day itself, my lord, I appeared before the IO, my lord, before the Harsang PS, my lord. And when I appeared before the IO, my lord, IO on one excuse and other excuse, my lord, he was very much there in the police station, my lord, but he did not record my statement, my lord. Thereafter, after waiting for so many time, much time, my lord, I had to go. And again on 16/3, my lord, 2020, 16 March 2020, I again appeared before the IO, my lord. That day also, my lord, he was very much present before the PS, my lord, but my statement was not recorded. And thereafter, again on 10, my lord, without recording my statement under 161, as I was ready to give my statement, my lord. On many occasions, I appeared before the IO, but my statement was never recorded. But instead of recording my statement, my lord, on 10/10/2021, my lord, the IO has filed an application before the session judge, my lord, at Konsa. And session judge, on receipt of the complaint, my lord, for cancellation of the bail, has registered that complaint as, my lord, can see from the order, my lord, criminal revision, my lord. My lord, may I take you to order passed by the, my lord, may kindly turn to page number 33. Annexure 6. The rest of the document, my lord, I am skipping because we are only on the point of this.
Whether revision lies?
Yes, my lord. Now, my lord, can see from this order, my lord, on the very top of this cause title, my lord, it has been mentioned as criminal revision number 3 of 2020. State of Arunachal versus Dajan Impo, the petitioner, my lord. In fact, the petitioner, my lord, is a respectable person and is now working as instructor, skill development and entrepreneurship. My lord, may I read the order passed by the Lord Session Judge, my lord?
It's
Today,
yes.
Today, criminal revision case number 3, 2020 is fixed for judgment and order. The state is represented by learned PP, so and so, my lord. Now, my lord, I will skip rest of the portion, my lord. Now, my lord, come to page number 40, my lord. The operating portion, my lord. In view of entirety of the case, it is found that the bail order that is passed by executive magistrate Changlang is in violation of established procedure under the law, and the same is passed as the respondent accused Dajan Impo has misleaded executive magistrate by concealing material fact and misrepresenting. Hence, the order of bail that is so and so passed in
Where are
bail
you
application
reading?
number
Page 40.
page 40, my lord. Page 40, last para, my lord. In view of the entirety of the case, it is found that the bail order that is so and so is passed by executive magistrate Changlang is in violation of established procedure under the law, and the same is passed as the respondent accused Dajan Impo has misled learned executive magistrate by concealing material fact and representing. Hence, the order of bail that is so and so passed in bail application number so and so by Executive Magistrate Changlang in Kasang PS case number so and so IPC whereby accused Rajan Ipoh was allowed to go on bail is then set aside. Send back the case records and so and so. So on. No, my lord, this order, my lord, whether it is correct or not, my lord. While cancelling my bail, my lord, what aspect was taken into consideration, my lord? That is not the issue now, my lord. My only issue is this order has been passed in a revision petition, my lord. Law does not provide any revision against any interlocutory order, my lord. Now, the issue comes, my lord, whether the bail, granting of bail or rejection of bail is an interlocutory order or a final order, my lord. If it is a final order, my lord, revision can lie. But my humble understanding is that granting of bail and rejection is an interlocutory order, my lord. I have so many judgments on it, my lord. I'll just place one or two, my lord. My lord has understood the case, my lord. Am I able to, my lord?
No, assuming that it comes to the notice of sessions judge that the magistrate has exceeded his jurisdiction, executive magistrate has exceeded his jurisdiction by granting bail where he does not have the power. What would have been the appropriate course open for the
That the open appropriate recourse, my lord, would have been this application under 439, my lord, for cancellation. 439
no,
of-
whether suo motu revision?
No, my lord, I am saying that, my lord, no revision at all is lies, my lord, against interlocutory order, my lord. We are not on that, my lord. The bail order passed by the executive magistrate was mechanically passed or not, my lord. Even we are not on that, my lord. Even we are not on that, my lord. While cancelling the bail, my lord, this is granted by the
So
executive
your
magistrate, my lord.
only ground is that the order of the executive magistrate was an interlocutory
Yes,
order,
my lord.
and therefore the sessions court could not have taken cognizance,
Yes, my lord.
exercising
Exercising revision of power,
revisional
my lord.
jurisdiction.
Yes, my lord.
Okay.
Now, my lord, to that effect, my lord, I have some judgment, my lord. My lord, it must be in the file also. In so many occasions, my lord, I have placed judgment, my lord. It was put to the record, my lord. My lord, this, my lord, first, we take up this judgment, my lord. It is passed, Honorable Apex Court, my lord. I'll just, my lord, take you to the only relevant portion, my lord.
Which para?
My lord, para, my lord, 6. Para 6, my lord. My lord, got it, my lord. In support of, may I read, my lord? Para 6. In support of this application, it is further contended that the law is very well settled and an order of refusal of bail is.
This is not an order of refusal of bail. This is grant of, your bail was granted. This is not the case which you are showing that relates to refusal of bail.
Yes, my lord.
But in your case, bail was not refused, it was granted.
Yes, my lord.
Whether refusal of bail and grant of bail are one and the same thing.
My lord, my lord, can you read the last sentence of this para itself, my lord? Let me read, my lord. In support of,
Granting or rejecting.
yes, my lord. It is submitted that this honorable court in its order that is so and so has not noticed that an order granting or rejecting bail is always considered to be an interlocutory one, my lord.
It is submitted. This is a submission only. What you are reading is a submission.
Yeah, my lord.
That is not finding of the court.
Yes, my lord. Now, my lord, I'll place another judgment, my lord. This is
So this you are not relying.
my lord. Yeah, I have better one, my lord. My lord, kindly come to para 8A, my lord. Well, let's give rest. This is the findings, my lord. Now, my lord, para 8 at last page, my lord. Para 8A.
Yes.
Coming to the revision cases, with regard to the statement made by the learned senior counsel for the petitioner that the accused has settled so and so, it has to be pointed out that no plausible material has been produced to substantiate such payment to the contractors. Further, in respect of the submission made by the learned senior counsel in the revision cases filed against the order of the magistrate, cancelling the bail already granted this order by invoking its inherent power under section 482 of the Code of Criminal Procedure can very well grant the relief sought by the petitioner. The objection contention raised by the learned government advocate, these revisions filed against the order passed by the magistrate, which is interlocutory in nature, are not maintainable, cannot be simply brushed aside. Learned government advocate in support of his contention has relied on the decision of this court reported in so and so, the Madras Journal so and so, Samra versus so and so, wherein it has been categorically held that an order of cancellation of bail is an interlocutory order and no revision would lie against such order. I am in entire agreement with the position laid down in the above case law of this court, both on merit as well as on the ground of mental illness. The criminal revision cases have to be dismissed. In view of the foregoing reasons, I do not find any merit in this also.
This is also a case of cancellation.
But then, my lord, the ratio, my lord, in all these cases is that, my lord, granting and refusing, my lord.
Where is the word granting? You have not shown that. If you are relying on a judgment, let the judgment speak.
Yes, my lord. My lord, I had some better one, my lord. I am not able to find it out now. It is in my this great wisdom. I'll try, my lord. Page 68. Now, my lord, it must be, my lord, a case squarely covering my case. This case, my lord. Whereas, my lord, 68. Page number 18, my lord, whereas 68.
Yes.
May I read, my lord? In context of the ratio laid down in the judgment discussed herein above, there is no difficulty in accepting the submission of the appellant that an order granting or refusing bail is an interlocutory order. Clause 1 amendment provides that no appeal would lie against any interlocutory order passed with the. This was the case of this, my lord, Maharashtra and this something like that, my lord. But the ratio, my lord, arrived at, my lord, it was that granting and refusing bail is an interlocutory order, my lord. Now, my lord.
Your submission is that the IO filed an application.
Yes, my lord.
PP ought to have filed an application for cancellation of bail.
Yes, my lord.
Before which court?
It can be either before the session court and high court,
can
my lord.
cancel it.
Yes, but
So the application should have been a application for cancellation of bail instead of revision.
revision, my lord. That is only my case, my lord. Yes, of course, in merit also, my lord, I have made environment with my revision petition, my lord. But I am not on this.
Now you are behind the bars.
No, my lord. I was never on surrender, my lord. only on the
Oh,
surrender,
this was stayed.
Yes,
Yes, ma'am.
Okay.
only when I surrendered before the magistrate, my lord.
This is one judgment for interlocutory. Okay.
Yes, my lord. And relevant they are, no, yeah, my lord.
Four 39(5). What is the
Yeah.
provision?
Your Lordship, actually, here the prosecution has two line of argument. First is mentioning of wrong provision. Because the session court and the high court has a concurrent jurisdiction so far as granting of the bail and cancellation of bail is concerned. And so far as your Lordship, the order is concerned, it was challenged not on the violation of the ground, it was for the perversity of the order. The order is perversity for setting aside of the same, which is, your Lordship, provided in section 439 of the CRPC itself, subsection 2 for cancellation of bail. So now, your Lordship, the
No,
statute,
I could not get this point.
your
One
Lordship,
second.
the question here is the order which was, he's on interlocutory order, your Lordship.
This is an interlocutory.
Yes. Now, your Lordship, my two line of argument is there. First, later on I will come to the interlocutory. Even without going to the interlocutory, the first line of argument would be, your Lordship. Under section 439 subsection 2, your Lordship may kindly come.
Yes.
A high court or court of session may direct that any person who has been released on bail under the chapter be arrested and commit him to custody. Here, your Lordship, the cancellation of bail power is exercised by the high court and the session court under the subsection 2, your Lordship. So now, your Lordship, here, the order which has been challenged or which has been brought before the notice of the superior session court is on the ground of perversity of the order, not the violation of the condition. So when there is a order is perverse in nature, then it is the superior court which will exercise its power under 439 subsection 2 to setting aside the bail order, your Lordship. Now here is,
Which order you are saying perverse?
your Lordship, the order passed by the executive magistrate. Yes, your Lordship. It's very apparent, your Lordship, from order itself. No CD was called for, no opportunity has been afforded to the state, and in mechanical manner, bail has been granted. So now, your Lordship, the question is, mentioning of wrong provision will not take away the power of the authority when the power itself is traceable from the enable provision is traceable from the court, your Lordship. 439 is traceable, your Lordship. Nomenclature, I will, your Lordship, rely some two judgments on that, your Lordship. Under 439 subsection 2, the session court is well within its jurisdiction to exercise that power, your Lordship, for cancellation.
Yes.
It's only the mentioning of wrong provision because the investigation officer has not filed a application mentioning, invoking, your Lordship, revision jurisdiction. It's only mentioning for cancellation of bail. But learned session court has just mentioned the name nomenclature as, your Lordship, as exercises jurisdiction as 397. However, the same power is traceable under section 439 subsection 2 of the CRPC. And the second line of argument would be, your Lordship, regarding interlocutory order, your Lordship. Now, your Lordship, it is well settled that the interlocutory order are those orders which are procedure in nature, procedure order, which does not affect the right and liability of a parties and is step toward the process of final adjudication. Meaning thereby, and your Lordship, it is well settled also, the bail is not a matter of right. It's a matter of discretion the court will exercise and it will not have any impact on the main proceeding. If criminal proceeding isn't pending, if bail is filed, it's an interlocutory nature. Even if bail is granted or rejected, it will not have any impact on the main pending proceeding, your Lordship. So it's a purely an interlocutory order, which has been well settled in Madhu Limia case, your Lordship. So far as, your Lordship, now, again, the question here is, the second part line of argument would be, even if it is interlocutory order, it is well settled by our own Honorable High Court, wherein my brother was one of the counsel, where it has been held that even if this is interlocutory order and it is perverse in nature, where exercise of power by interference by the High Court or the Session Court under revisional jurisdiction is indispensable, then for ends of justice, court can exercise its power under 397.
Even if it is interlocutory.
Yes, Your Lordship. Here, Your Lordship, this is the judgment, Your Lordship, of our own Honorable High Court, Your Lordship, the coordinate bench, Your Lordship. In Ligo Ori versus State of Arunachal Pradesh, this is reported in Supreme today, 24 Supreme Guwahati, 11 page number. Your Lordship may kindly come to page number 20 first. Para 20, sorry, page not 20, para 20. Your Lordship.
Vikramjit Singh.
Yes, para 22.
Para 20.
Yes, Your Lord.
Yes.
It is settled principle of law that bail order is considered as an interlocutory order. But here in the instant case, as discussed above, it is seen that the learned session just passed order casually and granted bail to the accused respondent number 2 without any reasonable ground. The only ground of bail was that the respondent number 2 accused is a local person and he has the business in Alo area. The operative part of the order dated so and so passed by learned session just in BA number so and so is extract here in below. Admittedly, the accused is a local of this area and is said to be doing business within Alo town. The applicant father is also resided within the jurisdiction of this court. Considering all this fact, this court is of the view that the accused can be released on bail with some strict term and condition. Accordingly, it is ordered that the accused so and so shall be released on bail on execution of bond on following condition. Now, Your Lordship may kindly come to para 24. After discussing many judgments, Your Lordship, of the FX court, this honorable come to the conclusion. Here in the instant case, it has been seen that the bail was granted very casually without any justified ground in spite of the fact that the allegation of sexual assault is brought against the accused. More so, it is seen that at the time of granting bail, the statement of the victim under section 164 CRPC was also not recorded and no opportunity of hearing was given to the victim informant side while passing the order of the bail. It is a fact that the notice was issued to the victim and physical presence of the informant is also recorded by the learned session judge, but there is no reflection in the order is in regard to the submission made by the victim informant side, if any, nor the learned session judge took any step to appoint amicus curiae to conduct the case, that the order of granting was palpable. Thus, it is seen that the order of granting bail was palpably illegal and perverse, which amount to miscarriage of justice. Accordingly, in present circumstances of the case, a petition under section 397 subsection 2 is maintainable and bail order which is palpably illegal and perverse can interfere with by this court. This is the observation of the coordinate bench.
Now I have to either agree.
Or yes, Your Lordship. Now, actually, Your Lordship, what my actually early understanding was, Your Lordship, under 397, there is a bar for interlocutory order. It is a admitted fact. It's a settled law, Your Lordship. I have come across, Your Lordship, many judgments where Supreme Court says, if there is a embargo under a specific provision of the statute, then court should not require to exercise 482 power. But even if it is interlocutory, if court find that if to prevent the abuse of process and for the ends of justice, if the intervention of the Honorable High Court under its inherent jurisdiction is indispensable, then court can invoke inherent power under section 482. But here, Your Lordship, this has been
Done by.
interpreted in, and this power has been even conferred in 397. But it should be, in fact,
Then
Your
there
Lordship.
will be no bar.
Yes, Your Lordship.
If-
Exactly, Your Lordship.
If we go by that, then there will be no.
No bar, exactly, Your
In
Lordship.
every case, we will show a reason
Yes.
and
482, actually, Your Lordship, according to as per my understanding, it should be inherent power, not the revision. Because since it is not, as on that it has not been, Your Lordship, challenged, but Your Lordship, this is the observation which was made by this Honorable Court. And secondly, Your Lordship, may kindly come to para 2, Your Lordship. Interestingly, Your Lordship, that para 2, Your Lordship.
of this.
This, yes,
judgment.
This application was filed under 439(2). The nomenclature was 397, Your Lordship. Again, interesting part, Your Lordship. So that is the reason, your lordship, what I am
That
trying,
court could have cured
yes, your lordship,
if it is application under
439-2.
39(2).
Yes, your lordship.
It should have treated it as 439(2).
2, yes, your lordship. Same, your lordship. The first line of argument, my first line of argument was, it should be treated as 439(2), and the learned session court is well within its jurisdiction to exercise its power, which is traceable from the statute, and there is no any bar as such to exercise under 439 subsection 2.
But no application was filed by the, who should have filed the application for cancellation of bail?
Your lordship, cancel,
PP.
so far as cancellation is concerned,
PP should have filed.
your lordship, even if suppose, your lordship, there is no bar that even the IO cannot approach the court directly, your lordship, because, your lordship, what we have seen in the district courts, there are no permanent public prosecutors. There are panel of counsels. Among them, the court appoint a particular counsel to act as a public prosecutor in particular case, your lordship. Maybe that may be one of the difficulty, your lordship. The IO has directly approached the court by filing the way of application, but it is brought into the notice of the court, your lordship. And your lordship, so far as the mentioning of wrong provision, I would like to rely to judgment if your lordship allow.
No, it is not a case of mentioning of wrong provision. It is case of, because IO has not mentioned any provision.
Yes, your lordship.
It is case of exercising of powers
39.
purportedly under
397.
397.
But your lordship, the 439 power, the basing on the power, although no, that your lordship, nomenclature 397 was there, but the power exercise, the discussion and the consideration was made made as if it has been
Power
considered.
was there with the session.
Yes, that is what I'm trying to, your lordship, project. The power was there. It is not a case that if 397 goes, everything goes. No, the power is traceable under 439 subsection 2.
So the session court was not powerless.
Yes, exactly, your lordship. That is my submission, humble submission.
But my lord, in any case, my lord, since this case,
You want to cite any?
Yes, your lordship, regarding your lordship, the wrong mentioning of wrong provision in criminal case itself, it's not a general law, in criminal case itself.
Give one judgment only.
Okay, your lordship. One judgment.
my lord,
Because if it is on the same point, don't give many judgments.
Yes, yes, okay.
Give the best judgment on which you are relying. Let him,
yes, my lord.
yes.
Yeah, no. Now, my lord, any application, my lord, it has to be accompanied with this affidavit and verification, my lord. If at all this was, let us assume that this application, which is filed by the IO, my lord, before the session court, my lord, it is an application under 439. Let us assume that. Then in that case also, my lord, the High Court rules prescribe that that application has to be the, my lord, accompanied by this affidavit. Since there is no, my lord, the identity even of the IO, my lord, it is doubtful, my lord. Therefore, my lord, to confirm
Who filed the application?
the IO, my lord, IO of the case, my lord.
Have you taken ground?
No, my lord.
Have
Because,
you no, have you in this petition,
no, my lord.
have you taken that
No,
ground?
I have not taken that. But that is the rule only, my lord, which governs the filing of any application, my lord.
How will we assume that the application was not filed?
I have, my lord, annexed the application, my lord, in my application.
Where is the application?
May find it in.
On what ground the sessions court
Yes, your lordship.
rejected the bail? Mainly, what was the ground?
Your lordship will directly come to page number, your lordship, 40, your lordship, 40.
Yes.
Third para, your lordship will find. It is observed from the record of the case that respondent accused while filing bail application number 1520 has concealed the fact that his anticipatory bail application was rejected by the High Court, as well as this court. Such concealing of material fact that the accused respondent has misled the executive magistrate or otherwise as per the judicial propriety when a bail application rejected by the different high courts The subordinate court should not allow the same. On the other hand, the executive magistrate has not called for the case diary, nor has sought any report from investigation officer regarding the status of the investigation. Learned executive magistrate had not even heard PP before granting bail to the respondent accused, which is mandated under the law. Your Lordship, is very apparent. No CD was perused. Status was not seen, Your Lordship. Even the PP was not given an opportunity. The violation of natural justice, in fact, Your Lordship. The state must be given an opportunity as well.
Okay. Which judgment you are?
Yes, Your Lordship. Para 22.
Now, what will happen if his revision petition is dismissed?
If this is dismissed, Your Lordship, then
He may be arrested at any time, or
yes,
he
Your
has to
Lordship.
surrender.
Or Your Lordship may have a liberty, a specific time that in the meantime he may be given time to file a bail application afresh before the concerned court.
My lord, the offense, my lord, the alleged offense, my lord, it was committed in the year 2020, my lord. And my lord, this,
Yes.
after my lord, the filing of the missing report, my lord, yes, regular case has been registered, my lord. Investigation, my lord, of course, I do not have the instruction right now, my lord. It is a case of 2020.
Now,
The
what
police might have even completed the investigation, my lord. In that case, my lord, cancelling the bail, my lord, granted by the executive magistrate, though it might have been purpose at that point of time, my lord. But it is the need of the
then
investigation
I have a
agency is
query.
Yes, Your Lordship.
Assuming that the revision is dismissed,
Yes, Your Lordship.
revision is dismissed, it would amount to upholding of the order of the sessions.
Yes, Your Lordship.
Then his bail would be cancelled.
Yes, Your Lordship.
Would be treated as cancelled.
Cancel, yes, Your Lordship.
Then either he may be arrested at any point of
Yes,
time,
yes,
or he has to surrender.
yes, exactly.
Now, the question is, after lapse of so many years, 4 years, the question arises whether his detention is required or not presently. That question automatically arises.
Yes, Your Lordship. But the question here is during the pendency of the trial also, Your Lordship, a person can pray for the bail, Your Lordship. Even after, Your Lordship, this
So
filing of
your
charge,
submission is that he may go to,
the appropriate forum
yes,
and pray for regular bail.
my lord may grant the regular bail from here and ensure the
no, not
this,
in 482. Again, I will not make that.
yes, my lord can direct always direct the subordinate court, my lord, session clerk, to release the petitioner in the event he moved
Your Lordship,
bail application before the session
Okay,
court, my
okay.
lord.
Heard, Mr. What is your name? Heard, Mr. D. Kamduk,
Yes, ma'am.
learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Daja Nimpo, impugning the order dated 20/12/2021, passed by learned Sessions Judge Khonsa in Criminal Revision number 3/2020, whereby the bail granted to the petitioner by order dated 11/3/2020 was cancelled. Stop. Okay. The facts relevant for next para, the facts relevant for consideration of the instant criminal petition are as follows. Number 1, Roman 1, that on 14/1/2020, one Shri Chandru Tanti had lodged an FIR before the officer in charge of Kharsang Police Station, inter alia, alleging that his son Sumit Tati, and Dilip Dhurap Tati, no, his son Sumit Tati, along with son of one Shri Sunil Rotia, namely, no, you have to correct this name. His son Sumit Tati, Dhurap Tati, along with son of one Sunil Rotia, namely Deep Rotia, were missing since 11/1/2020. Stop. It was also stated in the FIR that they were last seen playing near the culvert of RWD Road, Colony, Kharsang. Stop. On receipt of the said missing report, Kharsang PS case number 2/2020 under section 363 of the Indian Penal Code was registered. Why you were arrested?
My lord, it was alleged that, my lord, I have taken those
Boys.
boys, my lord. But my lord, it has, they have been recovered, my lord, they have given their statement that they on their own had come to Nahalagan, my lord.
No.
I had not kidnapped, my lord. The charge is, of course, my lord,
It's in
false, my lord. But that will be proved
Next,
in the
number
trial.
2, later on. Know how you came into picture. Some statement is to be. Who is Daja Nimpo?
This
Dajanappa, my
inquest-
lord, the petitioner.
Who are you? How you are related to the?
My lord, I was serving as skill development officer at Changla, my lord. These people, boys, my lord.
Why were you arrested?
My lord, I was not arrested. I moved bail application, pre-arrest bail application before the session closed. It was
Pre-arrest.
rejected. Then, my lord, I surrendered before the executive magistrate on that day, 11.
But why you apprehended that you may be arrested?
That, my lord, the police, my lord, was looking for me, and those boys was known to me, my lord. They came with me at Nahalagan voluntarily, my lord. But they did not, the boys, my lord, who came with me
Yeah,
at Nahalagan, my
Your
lord, they
Lordship.
did not.
The victim were last seen with the main
Yes.
accused as per the
Next,
investigation.
Number 2.
This
Is
edition of section.
it is submitted by learned counsel for the petitioner that as the police suspected involvement of the present petitioner in the incident of missing of the 3 boys whose names were mentioned in the FIR. You have mentioned that you have filed an anticipatory bail in this.
And,
You
yes,
have
my lord.
made a statement in this petition,
Yes, my lord.
or you have not made
No.
here also, because that is one of the ground
For cancellation. They have not mentioned
that you. What was the last name?
No, no, my lord.
Not
I have,
mention, Your
I have
Lord.
not mentioned, my lord.
Not mentioned.
Yes, here also.
Then though it is difficult.
No,
At
my
least-
lord. I have met my lord in Perapur, my lord. Perapur, my lord. When the petitioner came to know about his being what the session could have at Perapur, my lord.
Okay, okay.
I mentioned
What
that.
was the last name?
Oh, session I. After rejection. Okay.
FIR, the petitioner approached the Court of Learned Sessions Judge Khonsa, praying for anticipatory bail. However,
After rejection.
it was rejected by the said court. Thereafter, the petitioner surrendered before the Court of Executive Magistrates Changlang, who was in charge of the Judicial Magistrate Changlang on that day, as the concerned judicial magistrate was on leave. On his surrender before the executive magistrate, and a bail application was moved by the petitioner, which was allowed by the learned executive magistrate Changlang on by his order dated 11/3/2020. And the petitioner was allowed to go on bail of rupees 20,000 with 2 sureties of like amount and with certain conditions. Stop. The condition, one of the condition incorporated in the bail order was that he will appear before the investigating officer of the case number of the case of the concern of the said of the PS case number. What was the PS case number? We have mentioned of the Khonsa PS case number so and so. You have there is mentioned so and so on 12/3/2020 for giving his statement. Stop. Thereafter, the next paragraph. Thereafter, the investigating officer of Khonsa PS case number 2/2022 filed an application, comma, on 13/3/2020, comma, before the Court of Learned Sessions Judge Khonsa, praying for cancellation of the bail on the ground that the on the ground that the prayer for bail of the petitioner was earlier rejected by the High Court. You approached High Court also?
Yes, my both my lord.
High Court as well as Sessions Court. And the custodial interrogation of the petitioner was necessary for the sake of investigation. Stop. Next para. On receipt of the said application, the Learned Sessions Judge Khonsa registered a criminal revision case, namely criminal revision number 3/2020, and thereafter by order dated 20 December 2022. Exercise the revisional powers of the said court under section 397 of the Code of Criminal Procedure and cancel the bail granted to the petitioner by the executive magistrate by the executive magistrate by order dated 11/3/2020. So, Mr. D. Kamduk, learned counsel for the petitioner, has submitted that though in this criminal petition, the petitioner has also assailed the cancellation of bail order by the learned session judge Khonsa on merit. However, they are not pressing the said points. Rather, the petitioner is pressing the point that the order of the session judge was without jurisdiction Stop. Learned counsel for the petitioner has submitted that as the order of granting bail by the executive magistrate, in this case, is undoubtedly an interlocutory order. No revision lies against such an order, and the petitioner and the learned session judge Khonsa was wrong in exercising revisional power for cancellation of bail granted to the petitioner by the learned executive magistrate. Learned counsel for the petitioner has cited following cases in support of his submissions. Number 1, Roman number 1, Suman Thakur alias Mrityunjay Suman and others versus State of Bihar.
This is better one. That can also be there.
No, cut that. Instead of Suman Thakur, write this one. State of Himachal Pradesh versus Dileram, D-I-L-E-R-A-M, Dileram, reported in 2008 4 crimes within bracket HC 882, wherein it was observed by the High Court of Himachal Pradesh that an order of granting of bail does not decide the rights of the parties finally, and therefore it is undoubtedly an interlocutory order. Stop. Hence, such an interlocutory order cannot be assailed in revision due to specific bar imposed in the statute itself, that is under section 397 within bracket 2 of the CRPC, which bars a revision against an interlocutory application. Stop. Stop. On the other hand, Mr. T. Ete, learned additional public prosecutor, fairly submits that there is no dispute that an order of granting of or rejecting of a bail is an interlocutory application, and no revision lies against an interlocutory application. However, he submits that the session judge otherwise had the power of cancelling a bail under section 439 within bracket 2 of the Code of Civil Procedure. And if a power is traceable to a authority in a statute, mere wrong mentioning of the statutory provision would not take away the said power. He submits that in the instant case, the session judge rejected the bail granted to the petitioner by the executive magistrate mainly on the ground that the executive magistrate was misled by the petitioner, as the fact of rejection of anticipatory bail application by the High Court and by the Court of Sessions were not disclosed before the executive magistrate. Stop. Moreover, the Sessions Court also took into consideration the ground that the executive magistrate, without going through the materials and without going through the materials on record and without calling for the case diary, granted the bail to the petitioner on the date on which he surrendered before it. And hence, the Sessions Court rightly cancelled the bail granted to the petitioner. Stop. He also cites, I am not citing the coordinate bench judgment
Okay, Your Lordship.
because
Yes, there is a some.
I mean, because otherwise it has to be referred.
Yes. No, Your Lordship, it's okay. Even my understanding should be 482, Your Lordship.
Learned, where the wrong provision,
Your Lordship, it's I've given the judgment to Your Lordship, two judgment in Your Lordship, 2001 SCC 482, page number 22, Your Lordship.
learned additional public prosecutor has also cited a ruling of Apex Court in the case of BSE Brokers Forum, Bombay and others versus Securities and Exchange Board of India and others, reported in 2001 SCC 482, wherein the Apex Court has observed that
There are 22, Your Lordship.
that it is a well-established principle in law that so long as impugned power is traceable to the statute concerned, mere omission or error in reciting the correct provision of law does not denude the power of the authority from taking statutory action so long as its action is legitimately traceable to a statutory power governing such action. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned public prosecutor and have perused the materials available on record. I have also gone through the judgments cited by learned counsel, judgment cited at bar by the learned counsel for both the sides. The main issue to be decided in this criminal petition is as to whether the learned Session Judge Khonsa was right in exercising revisional jurisdiction for cancellation of bail of the petitioner, which was granted to him by the order dated order dated 11/3/2020. I'll pass the remaining part in chamber.
Okay.
I am rejecting your petition, rejecting your application.
My lord, may protect since.
Yes, I'll give interim protection.
Yes.
So for 15 days,
My lord.
during which you may appear before the court of having appropriate court.
Yes.
See, you may seek bail from that court within these
Yes,
15 days.
yeah.
And till 15 days, this court will give you protection.
My lord.
Yes.
Okay.
Okay.
Much
I
obliged.
have to go through the judgments.
Yes, sir.
Therefore, I'll
Yes, sir.
dictate the remaining part in the chambers.
Yes,
today.
sir. And Your Lordship, I've given two judgment on this. One, Your Lordship has reflected, other one is also there.
That I will
Okay,
reflect.
yes. Deeply obliged.
Yes.
Yes, and this is my lord, a regular second appeal, my lord. Today, this speaks for formulation of a substantial question of law. my lord. Today, my lord, the case speaks for formulation of substantial question of law. my lord.
You
This
have,
is- This
you
is
have-
second, regular second appeal. my lord.
notices were issued.
No, my lord, yes, my lord, the service to respond a complete, my lord, or Only, to that extent, my lord, I have already filed affidavit, my lord.
No, but notices have to be issued after formulation of the substantial question. First, substantial questions have to be formulated. Only after that, the case is admitted.
Today, then my lord may formulate a substantial question of law, my lord.
Where is the, in your memo of appeal you have mentioned? You have mentioned the
My
substantial.
lord. Page number 21, my lord, I have mentioned some
Page number?
2-1, my lord. Of this, my lord, today I have a draft consolidated 5, my lord, draft 5, my lord.
No, the substantial question of law which you have mentioned. What is the issue?
Issue, my lord, what
Tell me
happened, my
the-
lord? I, my lord, appellant, my lord, the plaintiff, my lord, file it, damage suit, my lord, compensatory suit, my lord, for demolition of my wall, my lord, against the present respondent, my lord, the dependent, my lord, before trial command. They appear, my lord, and accepted that, yes, we have demolished your wall, my lord, and but the sale deed, my lord, by which, my lord, I possessed the land, my lord, was not valid, my lord. That is their contention, my lord. Not valid, my lord. Now, on such admission, my lord, learned trial court, my lord, civil judge senior division passes judgment on admission, my lord. As the sale deed, my lord, was correctness of the sale deed was not the issue, my lord. Only the issue was for compensatory suit for
No. Who went to the trial court
me, my lord. Me.
seeking what relief?
I file a compensatory to damage suit, my lord. As my lord, dependent, my lord, illegally demolish my wall, my lord, boundary wall, my lord.
Okay.
Now, notice the issue, my lord. Dependent affair, my lord. Dependent file written statement admitting, yes, we have demolished your wall, my lord, but that said it by which I purchased the land, my lord, was not valid. That is their contention, my lord.
Okay.
Now, trial court said it, as the issue of the validity of the sale deed was not the issue, my lord. Only the issue was for compensatory suit, my lord, for demolition, my lord. The trial court passed judgment on admission in my favor, my lord.
Trial
Is they-
court decreed the suit.
In my favor, my lord. There is admission pass part of the dependent for demolition of the demolition of my wall, my lord, boundary wall, my lord. Degree was passed, my lord. Now, respondent
What was the relief granted?
relief, my lord, 7 lakhs, my lord,
Compensation was granted.
my lord. Compensation,
Damages were granted.
my lord.
Thereafter,
Thereafter,
the
they
defendant went on appeal.
appeal, my lord. Now,
But
in
appeal, it was reversed
yes, my lord,
against you.
against you.
In appeal, the
In appeal, my lord, what the learned past appellate court, my lord, look into the aspect of the sale deed, my lord. He said, my lord, is one para, my lord. The sale deed, though I purchased 20,000 square meter from the dependent, my lord. That is clear in the category in the schedule of the land also, my lord. But in one para, there is mentioned 1,000, my lord. Now, trial or appellate court look into whole that aspect of sale deed, my lord, in saying that, my lord, it is only 1,000, my lord. So, my lord, the dependent, my lord, exercise right to private defense by demolishing the construction wall, my lord, wall constructed by me, my lord. And accordingly, my lord, he dismissed the suit, my lord. So my humble submission is, my lord, this, my lord, there's a depending finding, my lord, of the both the court, my lord.
now where the first appellate court heard, what was the wrong committed by first appellate court?
Past application, my lord, Past wrong committed, my lord, is my lord, the
Wrong of, in the nature of substantial question of law,
my lord.
not in, on facts. On facts, we cannot go into.
No, my lord, but that's why, my lord, my past argument would be, my lord. My lord, here is a case, my lord, there is not a concurrent finding by the board of court, my lord. There is a different finding by the trial court and the appellate court, my lord. In such a situation, my lord, surely, my lord, the aspect of the fake, my lord, also can be looked in the second appeal, my lord. In the, yes, my lord, in when,
103.
when concurrent finding is there, my lord, surely, my lord, only substantive question of law, my lord. But in when there is a difference in finding of the board court, my lord, other aspect, my lord, can be looked into, my lord.
Under what provision?
Under section 100, my lord, 100, my lord. Now,
No, where we can look into question of facts.
my
Where-
lord,
where is
that,
it?
my lord, that is,
103.
that is not clear, my lord, but then it is in judgment, my lord. I rely the effects of judgment. That is, I do concede, my lord, normally that is the law, my lord, the in second appeal substantive question of law, my lord, not only the question of law, it is substantive question of law, my lord. Now, if, my lord, I indicate a FARA 12, 13, 14, 15.
No, you come to the,
FARA 13, my lord, I'm reading, 12, my lord, I'm reading. In the light of rebel contention, before awarding to the fake citizen herein, it would be stated at the outset that on a general principle of law laid down in decision referred by the learned senior counsel for the appellant, there can be no quarrel whatsoever. In case of such and such, the fake citizen arising therein was referred to and have taken note that 5 substantial questions of law has been framed. This court have arrived at the conclusion that such substantial question of law which arose therein had not been dealt with appropriately, since it has been considered in the light of the condition. It is in that circumstances this court was of view that the judgment of High Court is to set aside the matter is to be remitted to the High Court. In case of such and such, the issue considered was whether the High Court was wrong in interpreting with the question of fake in the second appeal. It was a case where both the court below arrived at a concurrent finding of the fact, and both the court have disbelieved the evidence of the witness. In such a case where such concurrent factual finding was rendered by two courts, and in such situation it has been interpreted by the High Court in the second appeal, this court was of view that the interpretation was not justified. However, it is appropriate to notice that in a said decision, this court had also indicated that such resistance against interfering is not an absolute rule, but when there is a purposity in finding of the court, which are not based on any material, or which when appreciation of evidence suffer from material irregularity of the High Court could be entitled to interfere on the question of fake as well.
where there is a perversity.
Purposity. Additionally, my lord,
Here, what is the perversity? In the instance.
purposity, my lord, past purposity, my lord. Undisputedly, my lord, that my suit, my lord, was for compensatory suit, my lord. It was not the issue of validity of the sale. It was not there, my lord. There was an admission on part of the dependent, my lord, saying that we had demolished, my lord. Now, accordingly, court passed the judgment. Passed the judgment now. Judgment, my lord. Now, appellate court, my lord, go beyond the pleaded case, my lord, and look into the validity of the title, my lord. That is sale deed, my lord. Whereas the sale deed was never challenged before any before the trial court or before the appellate court, my lord. So
That is the main issue.
great reason. Second, my lord, even if my lord assuming have jurisdiction, my lord, the misread, my lord, he past appellate court misread the sale deed, my lord. Because, my lord, yes, my lord, I do concede, my lord, if my lord, kindly come to sale deed, my lord. This is at page number 63, my lord. This is a sale deed, my lord. How the appellate court has misread this, my lord. Section 63, my or page number 63, my lord. This is sale deed, my lord. Page number 63, my lord. kindly turn by 6-3, my lord.
What,
Sale deed, my lord. This is a sale deed, my lord. How I'll indicate, my lord, how that as past appellate court has misread this, my, content of this sale deed, my lord. Page number 63, my lord, is the sale deed, my lord. 60, this is of my lord will see.
after misreading it, to what conclusion it arrived?
He direct, he did it, my lord, only 1,000 square meter, my lord. I have passes, my lord. Remaining 9,000, I did not, my lord. That is the, my lord. He conclude.
The sale deed was for 10,000 square feet,
Uh,
square,
20,000 square meter, my lord.
square meter.
My lord.
And the first appellate court say how it read the sale deed, that it gave right to you over how much land
1,000, my lord.
and remaining?
Remaining, again in the for remaining in the appellate court pass permanent injunction against me, my lord. That is other perversity, my lord. That also I have formulated substantive question of law, my lord. Second would be, my lord, he misread, my lord. Even thirdly, in a compensatory suit, my lord, that sale did not being challenged, my lord, that whether the appellate court, my lord, can pass a permanent injunction against me, my lord. That would the other substantial question of law, my lord, in this case, my lord. My lord, you can, page number 63.
Whether
my-
there was a relief sought for permanent injunction?
No, my lord. Nobody, my lord. That way, my lord. There is no. Yes, my suit was for compensatory suit, my lord, only, my lord. Now, sale it was not an issue, my lord. The very this legality of the sale deed not an issue, my lord. But the appellate court not only, my lord, misread it, my lord. Ultimately, he passed a permanent injunction against me over the remaining 19,000 square meter, my lord. That would be other substantial question of law in this case, my lord. Now, my lord, if kindly, my lord, page number 63, my lord. This is the sale deed, my lord. On the-
No, I am framing formally. Now. Mr. What is your name?
El Parme, my lord.
N. Parme, Learned Counsel for the appellant. I have gone through the memo of appeal as well as the documents annexed therewith. And after going through the materials on record and after hearing Learned Counsel for the appellant, following substantial question of law are formulated in this appeal. Number one, whether the first appellate court was right in adjudicating the adjudicating regarding title of the land based on the registered sale deed dated 8/9,
It is, my lord, sorry, my 8/7, my lord. I have the wrong-
8/7/2019. And holding that the appellant is entitled to only
1,000, my lord.
1,000
Square
square meter of the land mentioned in the said deed when there was no challenge to the said sale deed in the pending suit before the court. Stop. Next, whether the first appellate court misread and misconstrued the sale deed dated 8/7/2019 in arriving at its finding. Number 3, whether the first appellate court was right in granting a relief of permanent injunction to the respondents in a suit filed by the present appellant for damages when there was no such prayer for grant of permanent injunction. Yes, ma'am. You have to take fresh steps for the appeal is admitted. Let the appeal is admitted. It appears from record that the notices were issued to the respondent in this case before formulating the substantial question of law and before admitting the appeal. This court is of considered opinion that fresh notices are required to be issued to the respondents after admission of this appeal and after framing of the substantial question of law. Hence, the appellant is directed to take fresh steps for issuance of notice to the respondents by registered post with AD, as well as by usual mode within a period of 7 days from the date of this order. Returnable after 4 weeks. List
Obli-
accordingly.
Obligation.
My lord, here, the fact of the case is that appellant has filed one title suit, 8/22, my lord. And same has been dismissed by the civil judge UPR, which is at page number,
Civil judge,
senior division UPR.
what was the Sub-
Issue,
what was the
No.
pecuniary value?
pecuniary 87 lakhs.
Okay, so the appeal lies to this court.
Yes, my lord. My lord, here, the ground of rejection was that my gift deed was not registered as per Registration Act
Okay,
1908.
we are issuing notice.
Obliged.
Heard Mr.
Tony,
T. Longang,
Tony,
T. Tony,
yes, my lord.
T. Tony, learned counsel for the appellant. This appeal under section 96 read with order 41. Why you have mentioned rule 5,
My lord,
order 41, rule 5?
my lord, this was mistakenly written, my lord. It should be 96, my lord. Because I'm not asking for stay, my lord.
Stay,
Not,
yes.
not asking.
Section 96 of the Code of Civil Procedure impugning the judgment and decree dated 28/6/2024 passed by London Civil Judge Senior Division, UPR in title suit number 8/2023, whereby the suit filed by the present appellant was dismissed. Issue notice to the respondent and call for the case record of title suit number 8/2023 from the concerned trial court. The petition that the appellant shall take steps for issuance of notice to the respondent within 7 days from the date of this order, returnable after 4 weeks.
Oblige,
List according.
oblige.
Jail appeal.
Lordship, this is a jail appeal, Lordship. We have not received appeal memo, Lordship, till now. So the registry may be directed to serve us one copy.
Now, who has filed this?
This is jail appeal, Lordship, jail authority.
Whether legal aid counsel have been appointed?
Not till date, no such appointment, Lordship, because Lordship, we have not received the appeal memo also. This is the first time, Lordship, they have directly, Lordship, they have,
Then who prepares this memo of appeal?
Lordship, the registry will prepare, Lordship, and they will serve both of us from the state as well the legal aid council.
It has been already prepared.
So we have not received,
No,
Lordship.
my question is, who prepares this memo of appeal?
Lordship, this
Legal-
is jail authority, Lordship, actually.
No, legal aid councils are not preparing.
No, Lordship, they have been served, Lordship, the copy, Lordship.
So jail authority have. Okay. Next, this criminal appeal jail. Is there any delay or not? This criminal appeal jail has been registered. Now, what is the system here? The convict used to file a this criminal appeal has been registered on the basis of a memo of appeal filed by the appellant Srimati Sunita alias Bonita Basumatari through the Deputy Superintendent of Jail, District Jail Teju, where the appellant is presently detained, impugning the judgment dated 17/10/2023 passed by the Court of London Session Judge, Pasighat in Pasighat Sessions Case number 28/2022, whereby the appellant was sentenced whereby the appellant was convicted under section there is an error. In the judgment, it is mentioned 302 part 1.
Hmm.
It cannot be 302 part 1.
Yes, sir.
It has to be
304,
304 part.
exactly, yes, Lordship.
Three zero four part 1, convicted under section 3044 part 1. This is Garber judgment. 304 part 1. Though it appears that the trial court has erroneously mentioned in the judgment convicting the appellant under part 1 of the section 302 of the Indian Penal Code. As well as under section 201/34 of the Indian Penal Code. The appellant has been sentenced to undergo an imprisonment of 7 years and also to pay a fine of rupees 10,000, and in default of payment of fine to undergo further imprisonment for 6 months. Stop. As this appeal memo is forwarded by the Deputy Superintendent of Jail. No, cut this line. As this is a jail appeal and no one is defending, no one has appeared for the appellant, this court deems it fit to direct the registry to appoint
Legal aid counsel.
a legal aid counsel from the panel of the legal aid counsel prepared by it. Stop. Let the case record of Pasighat Sessions case number 28/22 be requisitioned from the concerned trial court. Stop. Let the memo of appeal, let a copy of memo of appeal along with a copy of judgment be furnished to the learned additional public prosecutor as well as the learned legal aid counsel to be appointed by the registry. List this case again,
2 weeks, Lordship.
after
After
appointment of the amicus curiae. After a period of 4 weeks.
Lordship. Obliged.
Item number 5. My lord, this is a criminal petition, my lord, filed under 482 of CRPC, my lord. This is in fact jointly filed by the complainant, accused and the victim, my lord.
Joint petition.
Yes, my lord. And there is a settlement.
What is the offense?
Offense is 324, my lord.
324.
Yes, of IPC, my lord,
Initially
This is
registered under
bailable.
326.
but non-compoundable, my lord.
What injury was caused?
The victim's hand was inadvertently cut, my lord, unconsciously by the accused, my lord. And they have stated in the,
Cut means severed.
it was not severe, my lord. And there was no intention to cause the harm also, my lord. That has been deposed by the victim and the complainant itself in the trial proceeding, my lord. I
Where
have
is-
annexed the reposition also, my lord.
At what stage the trial is pending?
My lord.
At what stage the trial is pending?
Now, my lord, the deposition of the victim is, yes, prosecution witness is, my lord, is complete, my lord, except for the IO, my lord.
Because then it is at the last stage.
Yes.
You face the trial.
But still, my
It
lord,
is already over. Quashing may be understandable if it is at the early stage of the trial. But your trial is near culmination only. And what victim has stated in,
my lord.
what victim has stated in her deposition?
My lord, may kindly come to
49.
statement of the victim is at page number 38, my lord. 38. Neither the complainant, my lord, he has seen the incident himself, my lord. He has.
No, we will not go into merit.
Yes, my lord.
Yes.
Yes.
Victim has implicated you or not?
No, my lord.
Not implicated.
Not implicated, and more so, my lord, the matter has been amicably settled outside the court, my lord.
It was shown to be accidental one, your lordship, in page number 38. When I passed by it, I was hit by it, and my hand was injured and FIR was lost.
What is to be done?
Lordship,
My lord, my, I said the proceeding, my lord.
if your lordship, this agreement is satisfactory, then it may be quashed, but your lordship, your lordship may kindly come to the agreement now. Yes, 35.
Yes.
Two parties, where the parties here to willfully compromise with each other without any coercive in relation to dispute arose on 2nd February between the parties. The conditions are, your lordship, only two. Both the party amicably solved the dispute among them. Second party shall not repeat the same act or in nature of future toward first party. This much is the condition.
No, is there bar of stage?
No, your lordship. Lordship, we have to understand one thing, your lordship. Even after post-conviction, quashing can be made. It is well settled in Ram Avatar case by the Honorable Apex Court. So now at this stage also, your lordship, if this court find that there is a remote and bleak chance, then your lordship, it will be amounting to abuse of process. Because other important matter will be there before the trial court, your lordship. That is one of the aspect, but there is no bar as such, your lordship. As on that held by the Honorable Supreme Court, your lordship.
This is a joint petition by all three of you.
Yes, your lordship. Victim
Whether
complainant.
victim has signed the affidavit.
that has
Yes,
to-
my lord.
Yes, 3 affidavit was filed. yes.
So, affidavit, my lord, is signed by the victim only, my lord.
Okay,
Surendra Kumar Joshi.
heard Mr. E. Kamduk, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been jointly filed by the petitioners. Number 1, write the name from here. Number 1, Lalit Janding. Number 2, Surendra Kumar Joshi. Number 3, Pasang Senior. Praying for quashing of the proceedings of GR case number 96/2022 under section 324 of the Indian Penal Code, presently pending before the Court of Learned Chief Judicial Magistrate UPA Papumpare, where the petitioner number 3 is facing the trial. Stop. The facts relevant for consideration of the instant criminal petition, in brief, are that on 1/2/2022, the petitioner number 1, Shri Lalit Jangding, had lodged an FIR before the officer in charge of Bandardeva Police Station, Inter Alia, alleging that on that day at about 8:10 p.m., the petitioner number petitioner number 3, namely Shri Pasang Senior, came to the office of the informant and asked for advance salary, and when the same was refused, it is cut off the hand.
No, my lord. Cut off the hand.
Hand is there.
Hand is
Hand
there,
is
your
there.
lordship. It's your lordship,
Right.
there in page number, your lordship will find page number 29. Injury certificate.
Where is the injury report?
Page number 29, your lordship. Size of injury 10 centimeter into 0.5 centimeter.
Cut injury.
Inside
And,
looking-
and what was the last line? Refused. He assaulted and inflicted a cut injury to the petitioner number 2, Shri Surendra Kumar Joshi, who was the cashier of the Satyam Ispat within bracket Northeast Limited, comma, causing cut injury over the hands of petitioner number 2. Stop. On receipt of the said FIR, Bandardeva PS case number. What was the police station case?
PS case number. सामाजिक नंबर क्या ना
2/2022 was registered under section 326 of the Indian Penal Code and investigation was initiated. Stop. Ultimately, on completion of investigation, charge sheet was laid against the petitioner number 3 under section 324 of the Indian Penal Code. Stop. During the pendency of the trial, the charges were framed. No, in the trial, the charge was framed against petitioner number 3 under section 324 IPC. When the said were read over and explained to the petitioner number 3, he pleaded not guilty and claimed to be tried. Next para. It is submitted by learned counsel for the petitioners that in the meanwhile, the parties have amicably settled their dispute amongst them and to that effect, they also executed an agreement, written agreement on 22nd August 2022. Stop. It is also submitted by learned counsel for the petitioner that in the meanwhile, on 2nd of February 2023, the victim, that is the petitioner number 2, accused is petitioner number
3, madam.
3.
Accused is 3.
3.
Yes.
Victim
is 2. madam.
Victim is 2. Who- In the meanwhile, the victim, who is the petitioner number 2, in this case, has already been examined in the case pending against the petitioner number 3 as PW1. Stop. And in his petitioner number, victim is lady or male or gender?
Male, all are male.
And in his testimony before the trial court, the petitioner number 3 now victim has been examined as PW2. Petitioner number 2 deposing as PW2 has stated before the trial court that he was accidentally hit on his hand and got injured. Learned counsel for the petitioner has submitted that as the complainant who was examined as PW1 and the victim who was examined as PW2 have not given any implicating evidence against the petitioner number 3, that is the accused, namely Shri Fasang Senior, and as there has already been an amicable settlement reached between the parties, it would be futile to proceed with the trial as the probability of conviction in such a in this case is very bleak, and therefore he prays that this court may exercise its powers under section 482 of the Code of Criminal Procedure and quash the pending criminal proceeding against the petitioner number 3. Stop. On the other hand, Mr. T.A. Lanet, additional public prosecutor, has fairly submitted that in view of the testimony of the victim and the complainant before the trial court, there is unlikelihood that this case would result in conviction of petitioner number 3, and therefore he also submits that it would be futile to further proceed with the trial, more so in view of the amicable settlement reached between the parties. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record, including the deposition of PW1 complainant, PW2 victim, which were made by them before the trial court. Stop. I have also gone through the written settlement agreement, which has been annexed in this case as Annexure 3. Stop. As the matter has been amicably settled between the parties, and as the victim has not implicated the petitioner number 3 in his testimony before the trial court, this court is also of the considered opinion that it would be a futile exercise to proceed with the pending prosecution against petitioner number 2, and under such circumstances to continue with the trial would only be an abuse of the process of court. Stop. More so, in view of the settlement arrived at between the parties, this court is of considered opinion that they may not be considered opinion that in the interest of justice, the pending prosecution against petitioner number 2 in GR case number, what is the GR case number? (96/2022) is required to be quashed, and accordingly this court, in exercise of its inherent jurisdiction, quashes the aforesaid GR case.
Much obliged.
This criminal petition is accordingly disposed of.
Deeply obliged.
Item number 6,
May I please, my lord?
Yes,
My lord, this is bail application under section 439 of CRPC.
for
439.
commercial quantity.
Commercial quantity.
Commercial quantity, ma'am. My lord, I have been charged under section 20, clause B, clause 2, subclause 2, clause C of
20B to
NDPS
C.
Act.
20B to C.
Commercial.
What was the contraband? What was recovered from you?
Cannabis.
My lord, may turn to phase 9, it's the FIR.
No, let me know what was recovered. What is the subject?
Cannabis, my lord.
Cannabis.
Ganja.
How much?
245.1 gram.
245 kg.
45 kg.
Oh,
It's commercial.
it is huge quantity.
Yes, now 37 will come, section 30.
37 will come. On what ground you are paying for bail?
My lord,
Investigation is complete.
No, your lordship, it's progressing. I've received the case diary also.
What is your ground?
my lord, may I proceed the FIR?
Yes.
May I please? I have the honor to inform you that on
No,
12,
you need not to read it.
Uh,
Which page?
my lord, page 9.
Page?
9. It
Yeah.
is the type copy,
FIR.
FIR.
No, FIR, you have already said that 245.1 kg.
Yes, my lord. My lord, based on that FIR, they have made a raid and they have searched on my abandoned house. On my abandoned house, the house have been abandoned for 15 years, my lord. For 15 years, it has been abandoned by me,
Okay.
and they have found that illegal substance. So, my lord, the house is 20 kilometers far away from my present location. And my lord, the seizure memo, it
What
is
is your
pasted.
name? Sharing Gombu.
Yes, my lord.
Okay.
My lord, seizure memo is in page 13. According to the seizure memo, it is crystal clear that it was not recovered from my
When were
possession.
you arrested?
I was arrested on 15th of March. My lord, it has been 162 days.
162 days.
Yes, my lord. And my lord,
After 18 days, you will get statutory bail
Statutory bail, if charge sheet is not filed.
if charge sheet is not filed.
Otherwise, your lordship, even the public prosecutor can pray for further time also, your lordship. It
Can be extended for
1 year, your lordship, 365 days.
365 days.
Yes.
Now his plea is that, what is your plea that this is not yours?
it was recovered from my abandoned house. It was not mine, my lord.
Okay.
And my lord, it was not specifically from my house, but nearby my house there is a small shed which was made for keeping the chicken. Or it is a very small place. It was recovered from there. And my lord, may please kindly turn to page 16.
Yes.
My lord, it is a forwarding of arrest accused person to the district and session judge. My lord, may come to last para. My lord, may I read that?
Yes.
The accused is no more required for custodial integration. My lord, from the first day, I have been complying with the investigation, and I'll make sure that, my lord, I'll comply with it. I'll
How
cooperate with it.
will you overcome 37? Section 37 says that you can overcome only if you are innocent. You have to show that there is no reasonable ground to believe.
My lord, it was recovered from my abandoned house, which was abandoned for more than 15 years by me.
Yes. What is there? What is the
Your
matter?
lordship is 161 statement he is admitting, your lordship. He's saying, if your lordship allow, your lordship. My name is Sharing Gombu and I am resident of so-and-so village. On 13/3/24 at around so-and-so hours, when I was sleeping, police team came into my house premises and they started searching the house compound. And 11 bags of cannabis were found inside my house premises. After that, police took to Kalaktang PS along with the bag of cannabis
You were
recovered from
sleeping in that house.
house, yes, your lordship, from my home. I have stored the cannabis for selling them to Assamese people who occasionally come to my village for purchasing cannabis. I have brought the cannabis from my farm, which I have cultivated at the hill of Wajir village. He is involved in cultivation also. My family member have nothing to do with the cannabis seized from my house.
Where is the Caesar list?
Seizure list, Your Lordship.
Have you annexed Caesar list?
Seizure witness,
Caesar list.
seizure list. Yes, my lord, it's in page 13.
13 is type copy, Your Lordship. 11 plastic bag of suspected ganja with 245.1 kg.
May I please, my lord? My lord, I have two houses. One is there at Weiser village. Now I'm presently residing at Kalaktan. And the village, the Weiser village where my house I have abandoned, it is more than 20 kilometers far away from my current location now.
You may have some other grounds. It was seized at night.
My lord, may I please? My lord, what interesting is here that they seized the item on 13th of March, they have seized the item, illegal item, whereas the seizure witness they have signed on 14th of March. But the police have written it on 13th of March. Whereas the seizure witness, they are my younger brothers. They were forced to sign the seizure memo. My lord, there is no independent seizure witness, my lord.
No, Caesar was made at night.
Yes, Your Lordship.
So whether there was a permission. to conduct-
Permission were not taken, my lord.
But it has to be looked into. Otherwise, Your Lordship, at this stage, the court has to presume that the official duty, whatever has been done, is done in accordance with.
Otherwise, materials are there.
That aspect can be raised during the trial, Your Lordship.
Because apart from your denial that it was abandoned,
Yes, my lord, I have denied that.
Even if we, Your Lordship, assuming that it's abandoned house, but he's admitting that he's cultivated for selling to the Assamese people. It's clearly he is admitting, and his son also stated, Your Lordship, the contraband of the cannabis belonged to my father, Siring Gombo.
heard Mr. Now you don't have a case on. Apart from, do you have any other submission?
My lord, they have not followed the procedures.
Which procedure has not been followed?
My lord, seizure witness, they have signed on the seizure memo only on 14th at the police station, not at the exact location.
No, which provision they have not followed? Which provision of NDPS? That provision, whether it is mandatory or not. Suppose you are able to show,
Yes.
even if later on, that some mandatory provision has not been followed, then it may help you. But not now.
52A, basically, Your Lordship.
If it is not followed, then you look into the. Heard Mr. what
My
is
lord,
your
the
name?
house has been abandoned for 15 years by me. I
But-
rarely visit there.
But apart from your submission, there is nothing in
Yes.
the case diary. Case diary does not suggest. It shows that. What is your name?
H. Takum, my lord.
H.
Takum.
Takum, learned counsel for the petitioner. Also, Mr. T. Ate, learned additional public prosecutor. This application under section 439 of the Code of Civil Criminal Procedure, 1973, has been filed by the petitioner Sharing Gombo, who has been detained behind the bars since 13/3/2024, within bracket more than last 162 days, in connection with Kalaktang PS case number 4/2024 under section 20B2C/25 of the NDPS Act, 1985. The gist of accusation against the present petitioner is that on 13/3/2024, the officer in charge of Kalaktang who is the first informant? FIR is type copy only.
FIR, Your Lordship, Your Lordship, it's in page number
Page
9, Your Lordship.
Page 9 is the type copy and
Who-
page
who is
10
the
is the
informant?
Padi Payang, Your Lordship, in column 6, Your Lordship will find in page number 9. Column 6, page number 9, Your
Yes.
Lordship. Complainant name Padi Payang.
One Padi Payang lodged an FIR before the officer in charge of Kalaktang Police Station, inter alia, alleging that on 12/3/2024, on receipt of information through local sources that one Shri Sharing Gombu, within bracket the present petitioner, is dealing with the business of cannabis, and he had stocked huge quantity of cannabis with him for sale. A search team was conducted. The search team was constituted, and a raid was conducted in the house of the petitioner. Stop. During such operation, 245.1 kgs of suspected cannabis, within bracket ganja, was found in 11 plastic bags from the house of the from the premises of his house. Stop. Learned counsel for the petitioner has submitted that the petitioner is not involved in the offense alleged in the FIR. He submits that the contraband was seized in this case from a house which was abandoned by the petitioner about 15 years ago. He also submits that the seizing authorities have also committed procedural irregularity in as much as though the seizure was made on 13/3/2024. However, the seizure witnesses have signed on the seizure memo on 14 3/2024, where it is.
My lord, they have signed the seizure memo on 14, but the
where-
police
from-
have
From where you are saying?
from police station. At police station, they have signed the seizure memo.
No,
But-
is there anything on record? from-
Police have written, they have changed the
Okay. Stop. On the other hand, learned additional public prosecutor, Mr. T. has vehemently opposed the grant of bail to the petitioner. He has produced the case diary of Kalaktang PS case number 4/2024 and has submitted that the quantity of ganja seized in this case is huge quantity, that is 245.1 kgs, which is also commercial quantity, and therefore, the embargo of section 37 of the NDPS Act, 1985 is applicable to this case. And as there are implicating materials in this case against the present petitioner, he opposes the grant of bail to him. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, and gone through the case diary of Kalaktang PS case number 4/2024. Stop. There is no dispute that the quantity of contraband seized in this case is of commercial quantity. Hence, apparently, the embargo of section 37 of the NDPS Act is applicable to this case. Stop. Though learned counsel for the petitioner has submitted that the contraband was seized from an abandoned house of the petitioner, which he had abandoned 15 years ago. However, the materials in the case diary, available at this stage suggests that the contraband was seized from the possession of the present petitioner. Regarding the procedural irregularity also, as alleged by the petitioner, it appears that what the Caesar witness says,
Caesar witness.
Wang Chen and Kejal Tingle, two Caesar witnesses.
Yes, Kezang Dorji.
Have they stated that they have signed on 14?
Your Lordship, they said they were sleeping and he has stated that the suspect contraband of cannabis belonged to his father, the present accused only.
Okay.
Implicating, Your Lordship.
What was the last line? There is nothing on record at present to suggest that the signatures of it may be on 14th. There is nothing on record to suggest the procedural irregularity as alleged by the learned counsel for the petitioner. Stop. As the instant case involves commercial quantity of contraband, and as the provision of section 37 of the NDPS Act is apparently applicable to this case, this court is constrained to reject the bail of the present petitioner due to statutory embargo of section 37 of the NDPS.
Deeply obliged, Your Lord.
Obliged, my lord.
Lordship, 439 application in connection with session case number 02/2021, arising out of under the case number 22/2020.
Lordship, may Lordship may not be take this bail application, Lordship, because Lordship, as per this the notification which is arising out of the same FIR, Lordship, the Honorable Court who have previously disposed of bail application may direct it to
Some
Report
other
is-
court
yes,
has
Lordship.
taken up,
yes, Lordship.
which
Already Lordship disposed of Lordship one bail application arising out of the
Why?
same FIR. When Lordship this is
by whom?
on 29/7, Lordship,
By whom?
by Honorable Justice K.A.T.
Okay.
Lordship. This is
So
the
it has to
notification,
go-
this is the order, Lordship.
No, Lordship, I have different grounds and different point.
No,
to
but
submit
it's
for this.
arising out of same
I have
FIR,
seen the
Lordship.
judgment and I have seen the bail order as passed on 29/7/2024.
This is a fresh bail
Lordship.
application. This is a fresh bail application.
Yes, Lordship.
Your earlier bail was rejected.
No,
It was
no,
not rejected.
no, not rejected. My bail was rejected at session court. Then I have come to
Lordship,
before this.
arising out of same FIR, Lordship.
Okay, okay, okay.
Another co-accused Lordship.
So there is a notification
Lordship, that
that if a bail order is taken up arising out of same FIR, it has to go to the same judge. That bar is there.
so it may be listed, Lordship, before that honorable judge. Well, because Lordship, on the coming week, Lordship, the honorable judge is sitting, Lordship.
I have seen the order here in 24 page, here in para 24, Lordship. Whereby it's stated before the court by a learned advocate that during the time of hearing, out of 38 of witnesses, only 4
No,
witnesses
no,
was,
we are not going into merit.
yes, Lordship.
We
But
are
I
now
have-
deciding whether this court can take it up or not.
Yes, Lordship.
The objection raised by PP is that because of notification number 32, this bail application should go to the coordinate bench, which has already taken up
Dispose of Lordship.
another bail application arising out of. So it will not be, it has to be listed before the coordinate bench.
But
Or you
in
have,
which circumstances,
or you have. to
difference
carry
and
this
grounds.
Notification.
but change in circumstances, different grounds,
Maybe any ground,
yes,
you can take it up before that court. Heard Mr. G. Fukon, learned counsel for the petitioner. Also heard Ms. L. Hage, learned additional public prosecutor, who points out that another bail application of a co-accused arising out of same FIR was considered by a coordinate bench of this court within bracket Honorable Mr. Justice K. Ate, bracket close, in case number, in BA number 45/2024. And therefore she submits that as per notification number 32 issued by the registry of the principal seat on 30/5/2024, this bail application should also be considered by the same honorable judge. Stop. In view of the submissions made by learned additional public prosecutor, as well as in view of the prevailing notification number 32 dated 30/5/2024, the registry is directed to list this matter before the appropriate
Lordship.
on to September, Lordship.
on 2nd of September. No, okay, on 2nd September.
Obliged.
Almost 1 minute.
So we'll take it up after lunch. You will take time,
Not much, not much.
but you will take some time.
Sometime.
So we'll take it up at 2.
Lordship, a small concern, Lordship, I could not be here this morning, Lordship, item number 18, Lordship. Here,
Item-
Lordship, I was supposed to bring records, Lordship, but we have not received records yet, Lordship.
Item number 18,
FAO, item number 18,
yes.
Lordship. This matter may be, Lordship, fixed after 2 weeks, Lordship. I
You
have
have
taken.
informed the
consent.
other side.
Yes, I have taken. consent.
What is your name?
MSG at the Lordship, for state, Lordship.
Your government counsel,
Yes, Lordship.
heard Miss G. Ate,
Additional AG.
learned
Additional senior government advocate. Lordship.
learned additional senior government advocate. Also heard Mr. A. Apang, learned senior advocate, appearing assisted by name, appearing for the appellants. Miss Ate prays for 2 weeks' time as the records which she was supposed to bring today could not be brought,
Yes, we are yet to receive the record.
as same is not yet been received by the Office of the Government Advocate. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
Pardon, my lord. I beg to mention item number 16, my lord. This matter may be adjourned, my lord, because last time LCR was called for. So I have today little bit difficulty, my lord. So matter may be listed after 2 weeks, my lord.
Any
Item
objection?
16.
No objection. was-
Third, Mr. N. Rama, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty, his personal difficulty. Ms. L. Hage, learned additional public prosecutor, raises no objection. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
My lord.
May I please your lordship?
Yes.
Deeply obliged.
I am mentioning item number 12, lordship. Here, what has happened, the paper book has been prepared, lordship, but we have not received any copy. So, in fact, all of a sudden we came to know it has been prepared, and I could not appear before the concerned court. So, if your lordship
Okay.
can kindly fix it on 4th, lordship.
Third, Mr. A. Bhattacharya, learned counsel for the appellant, who submits that though the registry has prepared the paper book in this case, however, the appellant has not yet received, learned counsel for the appellant has not yet received a copy of the same. Stop. The registry is directed to furnish copy of the paper book to the counsel for the appellant. And this matter may be listed again on 4th of September.
4th, lordship.
4th
Deeply
of
obliged, lordship. Deeply obliged.
My lord, this is a 439 application, my lord. Accused person, my lord, has been in custody for 73 days now.
How many days?
73 days.
73.
Yes.
What is
Now, my
the-
lord, CD was called for. I understand the CD has come.
Yes, I have
I-
received the case.
Just, my lord, the background of how the incident happened, my lord. On 10th of May, a call was received from one of my friends, the accused person. The accused person received a call from his friend from Itanagar, telling him that his elder sister has been attacked by his co-worker, the deceased now,
Okay,
by his co-worker.
co-worker,
Yes,
okay.
and somehow she has managed to escape and she has informed him that she is hiding in that place. So accordingly, the accused person, along with 2 of his cousins, went to the place where they were told that the sister was hiding. Now, when they reached, my lord, they found her there with serious injuries, and they told him that her co-worker has abused her, assaulted her. Now, that lady also filed an FIR. Their FIR is at page 21. Your lordship may kindly have a look.
Page 21 is FIR
Yes,
against whom?
against the deceased man. I am just pointing out what transpired, my lord, and under what circumstances the incident happened. Now, after the accused person found the, my lord, this lady, he also found the deceased person, and they took him first to a lawyer to draft this FIR. My lord, will see what is the content of this FIR kindly, page 21.
No. Who took whom?
My lord, the
The-
accused person, yes.
Present petitioner,
Yes, the accused person under custody,
he is under custody.
yes.
He took his sister,
My friend's sister,
friend's sister,
along with the person who allegedly assaulted her,
assaulted her to
yes. First to a lawyer,
a lawyer for
to drafting this FIR.
FIR.
Yes.
Okay.
Page
Then-
21, madam.
Yes.
I, Miss such and such, daughter of such and such. I am writing this letter to report a horrifying incident of attempt to murder and rape that occurred today on 10th May around 1 p.m. I was attacked by my colleague, Sri such and such. This is the deceased person, madam. Herein referred to as the accused, who is working as branch postmaster at the post office at Korunu. At around 1 p.m. while I was leaving after completing my day's work, the accused stopped me and started to argue with
The
me.
deceased was working as a branch post.
Yes, yes. and started to argue with me for no apparent reason. He then punched me in the face and hit me with an object on my head. I called for help, but no one responded. He then attacked me with a knife. I somehow saved myself and begged him to stop, but instead he dragged me by my hair to his room. There he kept hitting me. I managed to pull away the knife, but then he took a plier and stood out to attack me and pinned me down to the floor. I kept begging for mercy, but he kept assaulting me. I was choked by him while he was trying to sexually assault me. While I resisted, he tried to stab me again. I begged him to let me go. He stopped when my phone rang. I took the opportunity to escape from and ran towards the wine shop where I asked the shopkeeper for help. So it is at this wine shop she was found. Now, when she was found, the accused person did not know about this attempt to rape. When she was describing this to the lawyer, the accused person came to know about it. Apparently, the prosecution story is that when it was learned, he punched him, the accused person.
Present petitioner
Yes.
punched whom?
The
Milo.
Miloriki, yes.
Miloriki.
Yes.
The-
That will
Thereafter?
be in the CD, my lord. That is there in the.
Thereafter,
Thereafter, he was handed over to the police.
then when
It is
FIR
in the
against,
police custody. It is
who was handed over? Milo was handed
Milo
over.
was handed over.
You were not arrested.
No, no. While he was in custody, apparently it appears he expired
He expired in custody.
Custody.
Okay, then why FIR against you?
because I was the person allegedly who punched him.
Where is the FIR against you?
Page 17.
Which?
17. At this point of time, he had the Miloriki was alive.
Okay. Alive but in custody,
Yes,
11th. When he was
Yes.
arrested,
yes. This is to, Bainer?
just a minute. The FIR was 10th, next
Yes.
day.
Yes. This is to bring to your kind notice that on 10th May, a person namely Dehu Numre, that is the accused person, along with some unknown person has forcibly kidnapped my son, who is an employee of India Post. It is being learned that my son has been kidnapped and kept in confined for someone brought him back to police station Roing after brutally assaulting my son, unknown objects, and also attempted the life of my son. As such, my sustained serious brain injury and is under state of coma, fighting for his life, the ICU block at Dibrugarh Hospital. Such as that. This is the FIR. At this point of time, he was alive. So ultimately, consequently expired. Now, what I am submitting, my lord, is that apparently, my lord, this is not a case of murder. At best, it can be 304. Assuming for the moment, my lord, we accept the prosecution story to be true. There was no motive for, my lord, anything. It is because of that incident when coming to learn about the attempt to rape, my lord. That may have happened.
When Milo died,
I think on 11th. 11th
on the
or 12th.
next day,
Yes, ma'am. 11th or 12th, that will be the scene. What I am submitting is, my lord, what is the point of now, my lord, keeping me in further custody? These other two persons who accompanied me were immediately arrested, my lord. They have now been released on bail. These other two persons.
other two means,
There were two of my cousins were there,
by which court?
by the London Sessions,
On what ground they were released?
my lord.
On what ground they were released?
My lord, there was no allegation against. The allegation is that
They
I
have
am the
not
person who,
assaulted. Only you assaulted.
yes. that is. What I am submitting, my lord, is that what would be the point now, my lord, keeping me in custody? This is not a case that any further investigation is required. It is not a case that there was some planning and that murder occurred, my lord. It is an unfortunate accident, my lord. The initial incident was bad, my lord. Unfortunately, he expired, so there is no case against him now. So it is under such circumstances, we assuming, my lord, for the moment, accepting the prosecution story, that I am the person who beat him up, and because of which he died. Then also, my lord, what is the purpose of keeping him, my lord? 73 days have gone by now. It is my humble submission.
Yes, Mr. Ete.
My lord, this judgment, I don't need to rely, my lord, your lordship knows.
Which judgment?
And any, my lord, the Supreme Court judgments regarding, my lord, bail is the
No,
rule, not
unless you
jail.
rely, how will I know on which you were?
My lord,
You-
then I will just to refresh your lordship, my lord is aware of all these judgments. I will just rely upon one judgment, my lord. 2012 1 SCC,
What it
40.
says, what it says.
my lord, bail is the rule, jail is the exception.
Okay.
That is. And my lord, the ground on which the learned trial court rejected my bail was that after I was in custody, this Tadar Sumpi, my lord, she changed her statement in 164 statement. But by that time, I'm in custody. How am I supposed to influence her, my lord? The second 164 statement was recorded when I was in custody.
Whose?
This girl, my lord, who was allegedly assaulted by the victim.
This girl
Deceased.
is your friend's sister.
I did not know anybody.
She made any implicating statement against you
My lord, I'm not sure about it.
because she saw.
Yes, yes.
Okay.
Then, as of now, my lord, I'm accepting that I am the person I may have been beaten up. But what is the point in keeping me in further custody? That is my submission, my lord. Because it is not a case that the police gets any
And
further
you beat
investigation.
him up when you came to know that there was an attempt to rape.
Yes.
Then you became enraged and that is your
That
submission.
is. So what is the further point in my lord keeping? It is not a case that the police would require anybody else to be arrested, my lord. And there was some
Let us
conspiracy.
hear Mr. Ite. The mother is opposing.
Yes.
You are for the mother.
Victim.
Victim means
Mother.
mother of the,
Yeah, victim include deceased family member.
you are opposing.
Naturally. ma'am. But my lord will ultimately consider what would be the purpose now in keeping. There's only 17
No,
days
what
left.
Mr. Ite says, let us hear.
Now, your lordship, this.
The submission is that 73 days already behind the bars.
Yes.
And he's admitting that he had assaulted under such circumstances.
Yes, your lordship. Now, your lordship, before coming into the fact, it is also well settled that the position, to what extent he can influence the witness, all that aspects also has to be looked into. No doubt, custody interrogation, whether the requirement of custody interrogation is one of the aspects which court has to take into consideration, but other aspects are also there when the serious offense has been alleged to have been committed. This is 302, your lordship. It's a heinous offense. Its punishment is life or death, your lordship. And now, your lordship, directly I will come to the statement of the advocate before whom they directly went for drafting the FIR, your lordship. 164 statement of that advocate has been recorded, your lordship.
What he says.
May I read, your lordship? It's there's incriminating material against the present applicant, your lordship, regarding assaulting.
I've accepted it.
They have taken the deceased person from the office place of occurrence, and from there they taken them to his own house, applicant house. From there they have taken them, the deceased person, they keep the victim there, the victim girl there at his residence, and they have taken it somewhere else. Again they return and they taken the victim girl along with them to the this advocate place. From there they have assaulted the victim, and from there again they went to police station. There they hand over it to the police, and later on, because of the injury, the deceased succumbed.
Succumbed in the hospital.
Hospital in Dibrugarh, yes.
Police.
Police, there is no any foul play from the police as on that.
Whether police produce him before a magistrate after
Your-
arrest.
Your lordship, whether this person was arrested or not, your lordship, that I have to look into, your lordship, because I have, your lordship, gone through the statement.
Okay, how many persons were involved in assaulting? Only the accused or
Only the accused, and your lordship,
other two?
the girl was also there, so far as the statement is
Girl
concerned.
assaulted.
Girl also assaulted.
She was not arrested.
She was not arrested.
She's
Not an accused.
not an accused. In this case, she may be an accused.
No. She was not made an accused, your lordship.
No, but suppose during investigation it was found that somebody else is also involved, then
Yes, your lordship, that is the, your lordship,
that aspect is there.
that aspect is there, and that is the, in my
And
humble understanding, that is the discretion of the investigation authority as on that, because investigation is still
And
progressing.
other two who are released on bail, what was their role?
They were not, the other was, your lordship, is the brother-in-law, perhaps is the brother-in-law of this present applicant, your lordship.
There were two more persons.
Two more person.
Who are released on bail.
Yes.
What materials are there against them?
So may I read that, the statement of the advocate before whom the actually assaulted has been done, your lordship? May I read, your lordship?
Yes.
I am
Because
a-
if you read, they will hear. And they will know what is the content of.
That is there, your lordship. Otherwise, your lordship may peruse
No,
the 164.
But he is admitting that he had assaulted.
Yes, your lordship.
Yes, what the council says, what is the name of the advocate?
Advocate name is, your lordship, Bang Kong Libang.
What he says,
He says that, your lordship, only the part which is against
that
the,
incriminating part.
yes, your lordship. I saw Dehung Umre, the present applicant, coming from other side of the shop yelling at accused. I could not understand what exactly was he yelling. He started to suddenly assault the accused physically. I saw him punching him the face and head, grabbing him by neck and slamming him against the wooden shutter of shop. I intervened and stopped him and asked them to immediately leave for police station, which they obliged and they left, your lordship.
Now, what do you apprehend? The manner in which he was assaulted was brutal.
Yes, your lordship. And they have actually, your lordship, when the offense has alleged to have been committed, instead of taking the law in their own hand, they ought to have filed, registered an FIR, but they have taken this deceased person along with them. And they taken them to his own residence. From there, they have taken him to somewhere else. That statement is given by the lady victim itself, your lordship. And then later on they came back and then they taken the victim girl
Now,
to
who are the witnesses against him? The lawyer and the victim.
Yes, your lordship. The victim, your lordship, in 164, she has improved.
She has exonerated.
Yes, your lordship.
Now, what do you apprehend?
The statement so far, this
Lawyer may be influenced.
lawyer is the eyewitness, your lordship. This present lawyer. And your lordship, as per the report, your lordship, the cause of death was because of, your lordship, head injury, your lordship. Injury sustained and describe all injuries and mortem cause of blunt through impact, your lordship.
Now, what is your ground for opposing the bail?
Yes, my objecting would be, your lordship, since, your lordship, this category of offense fall under heinous offense, your lordship, wherein this court not only look into the aspect of custody interrogation, but the impact to the society as well, your lordship. The manner in which the offense has been committed, your lordship, and after commission of the offense, that person was absconding, and even LOC was, your lordship, issued by the police, your lordship. Lookout circular, your lordship. He was absconding, and later on, your lordship, he surrendered. And nature of, your lordship, the manner in which the offense is committed is one of the, your lordship, important factor, your lordship. If one's offense is committed, he ought to have filed a complaint before the police, your lordship. Instead of that, he himself has taken the law in his own hand and he assaulted the deceased person. And moreover, your lordship, he is president of some association, your lordship. There is a likelihood of influencing the other witnesses, your lordship. He is a president of Lower Dibang Valley Student Union as well.
By merely holding a post, how can you say that he would be?
Your lordship, this
As
the in Jagdish Singh matter, your lordship, the Honorable Supreme Court has stressed, your lordship, there are various judgment in bail, your lordship, no doubt. So somewhere says bail is a rule, somewhere says is an exception. Your in NDPS statutory, some statutory, so far statutory act are concerned, this is different aspects are there. But your lordship, all the aspects has to consider on the different case to case basis. Case has to be
So
considered.
your main apprehension is that
Influencing,
influencing.
and secondly, impact on society, your lordship, as well. Because that is also one of the factor, your lordship.
Impact on society means
Your lordship, because everything has been done in the broad daylight, your lordship, without and being a representative of a student union, your lordship, he has committed this offense, and after committing the offense, he has absconded, your lordship, and for that, your lordship, even LOC was circulated by the.
thereafter he surrendered himself.
Thereafter, he surrendered because, your lordship, there is no any possible of getting the bail at this stage.
Yes. Anything else?
Your Lordship, I will only, Your Lordship, I will rely the judgment, that's it, Your Lordship, but otherwise,
Which judgment?
Your Lordship, the Jagdish Singh and other versus Ashish Mishra, Your Lordship. Wherein, Your Lordship, the victim participatory right has been recognized, as well as, Your Lordship, it has been held that the discretionary power of the High Court and the Session Court under 439 are not unfettered, Your Lordship. The principle of granting bail has to be taken into consideration while granting.
What principle?
Yes, Your Lordship, is there, the certain illustrative,
What are they?
may I read, Your Lordship?
If there is some other principles. I have to
There are
consider,
27 to 30, Your Lordship.
there are 27 to
30, yes, Your Lordship.
in this case, what High Court overlooked? What was the case?
Your Lordship, here, Your Lordship, actually, initially what has happened, Your Lordship, here during the proceeding, the victim counsel was appearing, Your Lordship, through VC, but it got disconnected and they didn't get an opportunity to make submission. So on that aspect, they have approached the Honorable Supreme Court, wherein, Your Lordship, the settled proposition of law, what aspect has to be relevant consideration has to be made by the High Court while considering the bail. That has been reiterated, Your Lordship. May I read, Your Lordship? Para 27. We may at the outset clarify the power to grant bail under Section 439 CRPC is one of the wide amplitude. A High Court or a Court of Session, as case may be, are bestowed with considerable discretion while deciding an application for bail. But as has been held by this court on multiple occasions, the discretion is not unfettered. On the contrary, the High Court or the Court of Session court must grant bail after application of judicial mind following well-established principle and not in a cryptic or mechanical manner. Ordinarily, this court would be slow in interfering with any order wherein bail has been granted by a court below. However, if it is found that in such an order is illegal or perverse or is found upon irrelevant material adding vulnerability or to the order granting bail, the appellant court will be well within its ambit in setting aside the case and cancel the bail. This position of law has been consistently reiterated, including conversing Meena versus State of Rajasthan, wherein this court set aside the bail granted to the accused to the premises that relevant consideration and prima facie material against the accused were ignored. It is held that each criminal case presents its own peculiar fact scenario, and therefore certain ground peculiar to a particular case may have to be taken into account by court. The court has to only opine as to whether there is a prima facie case against the accused. The court must not undertake meticulous examination of the evidence collected by the police and comment on the same. Such assessment of evidence and premature comment are likely to deprive the accused of a fair trial. The High Court or Session Court can cancel the bail even in case where order granting bail suffer from serious infirmities result in miscarriage of justice. If the court granting bail ignores relevant material indicating prima facie involvement of the accused or take into account irrelevant material which has no relevance to the question of grant of bail to accused, the High Court or Court of Session would be justified in cancel the bail. Such order are against the well-recognized principle underlying the power of the grant bail. Such order are legally infirm and vulnerable, leading to miscarriage of justice and absence of supervening circumstances such as propensity of the accused to tamper with the evidence, to flee from justice, etc. would not deter the court from cancelling the bail. The High Court or Court of Session is bound to cancel such bail order, particularly when they are past releasing the accused involving in heinous crime, because they ultimately result in weakening the prosecution case and have adverse impact on the society. Needless to say that though the power of this court are much wider, this court is equally guided by the above principle in the matter to grant or cancellation of bail. It will be beneficial at this stage to recapitulate the principle that a court must bear in mind while deciding an application for grant of bail. This court in Prashanta Kumar Sarkar versus Ashish Chatterjee, after taking into account several precedents, elucidated the following. However, it is equally incumbent upon the High Court to exercise its discretionary judiciously, cautiously, and strictly in compliance with the basic principle laid down in a plethora of decisions of this court on the point. It is well settled that among other circumstances, the factor to be borne in mind while considering an application for bail are whether there is any prima facie or reasonable ground to believe that accused has committed the offense. Second, nature and gravity of the acquisition. 3, severity of the punishment in event of conviction. 4, danger of accused absconding or fleeing if released on bail. 5, character, behavior, means, position, and standing of accused. 6, likelihood of offense being repeated. 7, reasonable apprehension of witness being influenced. And danger of course of justice being toward by grant of bail. This much.
So here 4 and 7 are important.
Yes, Your Lordship.
Others I have not understood.
Yes, Your Lordship.
Like suppose if there is a prima facie and reasonable ground to believe that he is involved in commission of the offense.
Yes,
Then what should I, suppose there is a affirmative answer to this.
yes, Your Lordship.
Then what should be the course of action?
Yes, Your Lordship.
Bail should be granted or released, rejected. Assuming, let us consider these 8 guidelines.
Yes, Your Lordship.
Assuming that one is answered in affirmative,
Yes, Your Lordship.
that there is prima facie material to, then is it your submission that in all such cases bail should be rejected?
No, no, Your Lordship. Your Lordship, even Your Lordship, this come from the finding of the Honorable Supreme Court in the condition which is laid down under section 437 subsection 1 clause I, Your Lordship, is sine qua non for even granting bail under section 439. Your Lordship, it says when there is no reasonable ground to believe that the accused is committed an offense which is punishable for life or death, or death, Your Lordship, then court may not grant bail, Your Lordship. But
That
if
embargo
they-
is for magistrate courts.
But Your Lordship,
437,
Your Lordship, I have a judgment on
One-
that, Your Lordship, where
437 clause 1
I,
I
yes, Your Lordship.
is that embargo is for magistrate court only.
But Your Lordship, that has
Yes.
been, Your Lordship, in the case of Dinesh MNSP,
just
Your
a
Lordship.
Let us see. Four 37, which provision you were
Subsection, Your Lordship, 1 clause I, Your Lordship,
subsection 1,
clause I, subclause I, 1, Your, subclause Roman I, Roman 1, Your Lordship. Roman 1, not I.
1 is applicable only to magistrates
Your
court.
Lordship,
That is not applicable to
Your
high
Lordship.
court.
for my satisfaction, I will only read one paragraph, Your,
Yes.
that's it, and I will finish my argument. This is a
Dinesh MN,
Your Lordship,
what it says,
para 22, Your Lordship,
para
22.
yes.
May I read? It was also noted in the same said case that the condition laid down under section 437(1) sub clause 1 are sine qua non for granting bail even under section 439 of the code.
How you will understand this? That means in 439 also, unless you believe that there is a reasonable belief that the accused is not involved, you cannot grant bail.
And Your Lordship, that embargo is only confined to certain offense, not all the offenses, Your Lordship.
Yes, where the punishment
Is
is
for death and life.
death and life.
Yes, Your Lordship.
So your submission is that this embargo is also on High Court as well as Sessions Court.
Yes, Your Lordship. This aspect has to be taken into consideration while granting bail under 439, Your
It
Lordship.
is to be noted that said in the said case that the condition laid on is also noted.
The 439 power is not applicable to the magistrate, don't have 439 power, Your Lordship.
Yes. Then, let us understand this. Then even High Court and Sessions Court may not grant bail in any case where the punishment is life and death, unless it
Satisfied.
comes to a
Yes.
reasonable
The court must
Satisfaction
satisfy that
that
no
he-
reasonable ground to believe that.
that he is involved.
Yes, Your Lordship.
I have reservations. We have to understand this properly. Because if this is the law, then even High Court's hands are tied in cases where the punishment is life and death. In 302 cases,
Your lordship also find in section 436A. That section is also not applicable in your lordship, which the offense is punishable for death, your lordship. Where it says when under trial prisoner is
half of the.
yes, your lordship. Even that provision is not applicable when offense involve death, your lordship. Punishment involve death, your lord.
No, whether this judgment.
Not on all the offenses, your lordship. So far as
What is your,
How can there be a judgment, my lord, that is against the statute?
no,
The
but
statute
there
is
is,
clear.
that judgment, he is showing a judgment.
How can there be a judgment that is against the statute? That will not bind your lordships. It cannot.
full bench judgment, your lordship, Supreme
Whatever-
Court, your lordship.
Therefore,
Whatever
we
it
have
is,
to
my lord.
understand,
Yes.
Yes, your lordship.
because if this is
Judgment
what we
against
have to
statute.
follow,
Valid.
and if what you are saying is the law, then our hands are also tied. Then in no case where there is a reasonable apprehension, understanding of the High Court that the accused might have been involved.
Yes, your lord.
It is just like embargo of 37.
Yes, almost same, your lordship.
That
almost.
cannot be.
But your lordship,
I
I
have,
am just,
I have not come across this judgment. This has to be.
and your lordship, this is not for the first time the Supreme Court had said. In many occasions it has been reiterated.
That in 439 also, 437 1, Roman 1 is applicable.
That aspect has to be taken into consideration, your lordship. That Supreme Court says.
No,
And 439 power is with the High Court and the Session Court, your lordship.
it is to be noted in the said case that conditions laid down under 437 1 are signed for not. Then we have to go through this. Because this I am finding for the first time. You have to explain it. Mr. Panging, you also reply to this.
I have not gone through the.
You
judgment,
go
but-
through, you
But
go.
it is a settled law, my lord. There cannot be any ruling against the statute. How can
No,
there be a ruling? against the
I
statute?
want to understand this judgment. We'll take it up tomorrow. This matter will take it up tomorrow. Because if
But
this
my lord,
judgment is applicable,
On bail, my lord, there are so many judgments.
maybe
Supreme Court this way, that way.
you,
Ultimately,
you
your
bring a
lordship is-
counter judgment to this case.
No, my lord.
The, what,
Bail, my lord, I have never brought any judgment because it is ultimately your lordship's discretion.
no, what Mr. Ate is submitting that in 439 also, 437 clause 1, clause Roman 1 limitations are applicable. Which this in which
There are 22, your lordship.
Rajesh Ranjan's case,
Yes, Rajesh Ranjan's case.
we have also noticed from our- Read this.
May I
Let
read,
us
your lordship?
read.
Yes, your lordship.
Otherwise, my lord, let it come tomorrow, my lord. I will have a copy of the judgment and I will argue. my lord.
You argue, you.
Otherwise,
But
my
let-
lord, the
let him-
simple law is
No, that is my
Guidelines-
understanding.
guidelines does not bind your lordship while exercising 439 duty.
No,
How can that?
he's interpreting section 439.
Yes.
He
Four
submit,
thirty-nine has to be interpreted independently. No, it cannot bring in
No.
437.
yes, that is my
That
understanding.
is a simple law regarding interpretation of
It
statute.
does not seems to be as simple because he has produced a,
For the first time in bail application, my lord, I may have to bring in judgment regarding
Four-
interpretation of statutes
that too
tomorrow.
also of 439.
Yes,
Tomorrow,
all
we'll-
interpretation of statutes.
but you read this para.
Yes, your lordship. May I read?
Let us read.
Yes. It was also noted in said case that the condition laid down under section 437(1) sub clause 1 are sine qua non for granting bail even under section 439 of the code. In para 14, it was noted as follows. We have already noticed from the argument of learned counsel for the appellant that the present accused had earlier made several applications for grant of bail, which were rejected by the High Court, and some such rejection have been affirmed by this court also. It is seen from the record that when the fifth application for grant of bail was allowed by the High Court, the same was challenged before this court, and this court accepted the said challenge by allowing the appeal filed by Union of India, and another and the cancel the bail granted by the High Court as per the order of this court made in criminal appeal number so and so, dated so and so. While cancelling the said bail, this court specifically held that the fact that the present accused was in custody for more than 1 year at that time, and the further fact that while rejecting an earlier application, the High Court has given liberty to renew the bail application in future, were not ground events under section 439(1) subclause 1 of the code. This court also specified term held that condition laid down under section 437(1) subclause 1 is a sine qua non for granting bail even under section 439 of the code. In the impugn order, it is noticed that the High Court has given the period of incarceration already undergone by the accused and unlikely of trial concluding in the near future as a ground sufficient to enlarge the accused on bail. In spite of the fact that the accused is in charge of an offense punishable with life imprisonment or even death penalty. In such cases, in our opinion, the mere fact that the accused has undergone certain period of incarceration, 3 years in this case, by itself would not entitle the accused to being enlarged on bail, nor the fact that the trial is not likely to be concluded in the near future, either by itself or coupled with the period of incarceration would be sufficient for enlarging the appellant on bail when the gravity of the offense alleged is severe and there are allegations of tampering the witness by the accused during the period he was on bail.
That means only this observation. Mr. Panging, you clarify, and Mr. Ete also.
Yes, sir.
Tomorrow, this observation that this court, that is Supreme Court, also in specific terms held that the condition laid down under section 437(1) within bracket Roman 1 is a sine qua non for granting bail even under section 439 of the code. What does we mean by that? Whether it puts an embargo on the powers of High Court?
Cannot, man.
That is my understanding. It cannot, but how will we interpret this?
What I have understood, I have not gone through it. What I have understood is that bail, my lord, depends from case to case. In this particular case,
No, not
the
today.
Supreme Court has made an
You go
observation.
through,
These
you-
are also the considerations that also have to be taken into account. But can it be meant to understand, my lord, that the provision that is not there, which is being invoked, my lord, to as a remedy, how can that be read into it? Anyway, my lord, I will distinguish it.
Your submission should be, if it is not, how this court will overcome that observation made by Supreme Court.
But my lord, as far as
You-
bail
you-
law is
you-
concerned,
You show
this,
a way.
what the learned additional PP is showing, there are several judgments that says otherwise.
You show that judgment.
I have brought one, but bail is a discretion, that's why I was not showing.
No. You have to understand the.
I have
If it-
understood, my lord, since
my
your
dif-
lordship is taking up in that manner, I will bring. other
My
judgments
difficulty
regarding
is
bail.
how should this court overcome the observation made by the apex court in the judgment cited by Mr. Ete? It can be by a judgment of larger bench which
I don't think there is any other direct judgment on this point. Bail matters, your lordship knows there are observations in different cases. Jagjit Singh was in a totally different facts and circumstances of the case. I will
you
argue tomorrow.
go through this para,
My lord.
go through this para, and we'll take it up tomorrow.
Yeah.
Because these have an implication in.
But if
Not
your
only-
lordship goes in that, my lord, area now, your lordship will also in a bail application to decide how a statute has to be interpreted. Just because Supreme Court has said something, my lord, that will not bind you, because it is not a binding precedent, my lord, it is an observation. It is not a law laid down. It is an observation while dealing with something. Now, in a bail application tomorrow, I will argue, my lord, how a statute has to be interpreted, my lord. This is interesting.
You have understood my,
Observations, my lord, judgment as a precedent, my lord, is a precedent only when there is a definite laying down of the law.
no, you
It's
want
very
to,
interesting one. Now, in a bail application, it has been diversified so much today that we will have to make arguments in different fields tomorrow, like a writ court. Fine, my lord. We will make arguments.
you have understood
I
my,
have understood. I have understood. So to cut this matter, I will have to argue all other things in very different aspects of law also.
no, not other things.
You will have to, my lord. I will have to, because this is an observation. Is this a precedent that binds your lordship?
Yes.
I will so also does not.
Whether that
Yes.
this observation
Yes.
binds me.
Of course. That's what I was saying. In a bail application, now the argument has been enlarged so much that I will have to argue on different facets of law. Anyway, my lord, tomorrow.
Heard Mr. D. Panging, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor, as well as Mr. A. Tama, learned counsel appearing for the learned counsel appearing for the victim. Stop. During the course of the submission, during the course of the hearing of this bail application, learned additional public prosecutor has cited a ruling of the apex court in the case of Dinesh MN versus State of Gujarat, reported in 2008, 5 SCC 66, wherein there has been an observation made by the apex court in paragraph number 22 of the judgment to the effect that within inverted comma, this court also in specific terms held that the condition laid down under 437(1) within bracket small Roman 1 is a sine qua non for granting bail even under section 439 of the code. Stop. A specific query was posed by the court to the learned counsel for the petitioner as well as learned additional public prosecutor as to whether this observation puts an embargo on the power of this court to grant bail in a case involving offense where punishment is either life imprisonment or death penalty. Learned counsel for the petitioner as well as learned counsel for the petitioner, Mr. Dicky Panging, prayed for some time to answer to the query posed by this court. The prayer is allowed. You can also see whether this is the final law or not.
Let it be day after tomorrow, madam.
The day after tomorrow is,
Saturday.
Saturday is open.
Court is open.
court is open, but
Yes, sir.
Because
you will
the
take whole day for
the
that.
manner in which this issue has been raised, now I will have to produce judgments tomorrow. What are the judgments?
No,
that-
only this, therefore I
No,
have specified.
madam. With great respect, my lord. Whether this observation is binding upon your lordship, now for that.
I have
will to
clarified
provide
in
other
my order.
judgments.
I have clarified what I want.
Yes,
So
because
we'll-
I will not get a direct judgment that goes against this.
Yes.
I cannot.
no,
So
you
now
may-
I will have to place judgments, what would be a precedent that binds your lordships. So I have to go in a totally other way.
tomorrow we'll take it up in second half. At 2, we'll take it up.
Ultimately, the chamber time I get is today only, that
Oh,
is why.
yes, yes. Okay, day after tomorrow.
Right.
Let this matter be listed again on 31st of August 2011.
Because ultimately what the Supreme Court says, A judgment is a precedent for what it decides only. That is the law, as far as precedents are concerned.
Okay, you assist the court
I
in
will.
the best possible manner.
Item number 9.
9, my lord, case diary, he is here, my lord will pass order basing on the case diary. I will not make any other submission. My only submission is that it appears the applicant himself was not there. So under such circumstances, whether his custody interrogation will be required or not.
This is an anticipatory bail.
Yes.
The offense is
Allegations are that the
Your lordship, under BNSS, but BNS, the corresponding section of BNS, your lordship.
murder for
Murder, your lordship.
allegation is that, my lord, I run a my lord de-addiction center. Allegation is that my
Oh,
staff,
yes,
that one. I am not directly involved.
Sufficient materials are there, your lordship. His involvement, CCTV footage, he was seen there inside the, your lordship. This is a photograph. He has been identified, it has been marked, your lordship, and all the victim as well as the accused, your lordship, who has been arrested has clearly deposed his involvement. On his direction, everything has happened.
Third, Mr. D. Panging, learned counsel for the petitioner. Also, heard Mr. T. A. learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioner Shri Nasong Borang, anticipating his arrest in connection with apprehending his arrest in connection with Pasighat PS case number 94/2024 under section 103 within bracket 1. You also reflect, Yama, the name of, what is your name? For respondent number, for the victim. 1031, comma, and section 3 within bracket 5 of the Bharatiya Nyaya Samhita 2023. The gist of accusation in this case is that on, where is the FIR? On
FIR page 17.
20 July 2024, one Srimati Mohimang Litin had lodged an FIR before the officer in charge of Pasighat Police Station, inter alia, alleging that in the morning on the day of lodging the FIR, she came to know that her son, Olip Litin Mukherjee, was murdered in the rehab center, Gomin Nagar, which was owned by the present petitioner. Stop. On receipt of the said FIR, Pasighat PS case number 94/2024 was registered and investigation was initiated. Learned counsel for the petitioner has submitted that the present petitioner is only the owner. You are the owner.
Yes.
Owner of the rehab center where the deceased was admitted, and he has no role in his death. However, he has no role in the death of the deceased. However, police is searching for him only because of the fact that he happens to be the owner of the addiction center, namely Abundant Light Foundation, where the alleged incident had occurred. Stop. On the other hand, learned an additional public prosecutor, Mr. T. has produced the case diary of Pasighat PS case number 94/2024 and has vehemently opposed the grant of anticipatory bail to the present petitioner on the ground that in the case diary there are sufficient incriminating materials, including the CCTV footage and the statement of the other witnesses, where the implications have been made against the present petitioner. Hence, he submits that this is not a fit case where the benefit of section 482 of BNSS may be granted to the petitioner. Learned counsel for the victim also opposes the grant of the anticipatory bail to the present petitioner. Stop. I have considered the submissions made by learned counsel for the contesting, learned counsel for both the parties. This case involves offense of murder under section 103 of the BNS 2023. And on perusal of the case diary of Pasighat PS case number 94/2024, it appears that there are sufficient incriminating materials against the present petitioner in the case diary, which do not justify grant of anticipatory bail to him at this stage of the investigation. So for the reasons mentioned herein before, the prayer for anticipatory bail by the present petitioner is hereby rejected. Send back the case diary.
Deeply obliged. CD, that may be, CD may be returned.
Yes, send back the case diary.
Deeply obliged.
You give that judgment in the earlier case, a copy of that judgment to me.
Okay, Your Lordship. I've given it.
That is in the record,
Judgment.
in the earlier case where the a
Copy of
judgment was
judgment.
given.
2008, volume 5.
Yes,
I will check it, Your otherwise I will provide, I will put it in the record. Your Lordship.
yes.
Keep it in.
Okay.
Deeply obliged.
I will address your lordship also.
Item number 11.
Take out that. From the earlier case.
What's the map, please?
Yes, what is this?
This is quashing petition. Joint application filed by the alleged victim and alleged accused person. Also,
What is the
however,
offense?
during pending of this quashing petition, the alleged victim was commit suicide.
Committed suicide.
He is no more.
She is a lady.
Yes.
What
Minor.
was the offense?
POXO, Your Lordship.
POXO.
In fact, her age above 18 years during the time of committing offense.
Why she committed suicide? Because of this incident.
Maybe some other incident. Out of their relationship, one child, one daughter is blessed. And the
Then
minor
this
daughter
may
is
not be a proper case for quashing.
Your Lordship, it
appears.
is not at all proper case for quashing. And secondly, Your Lordship, may kindly come to their affidavit, Your Lordship. I would just like to indicate something. We have
moreover,
filed affidavit on
my
it.
lord, complainant, the private respondent is not present today. So let the private respondent maybe appear.
Your Lordship, may kindly see that
Otherwise,
paragraph.
complainant, private respondent, the complainant.
Okay, we are not disposing of it today.
Yes, private complainant not
What
present.
you want to show?
Your serious issue is there, Your Lordship.
Yes.
Yeah, we have filed affidavit against that affidavit also. Your Lordship, may kindly see para 2, Your Lordship.
Of
The filed by the petitioner, Your Lordship.
respondent number 1.
No, Your Lordship. Respondent number 1 is passed filed by us, Your Lordship, that affidavit.
What do you want to show?
Additional affidavit, Your Lordship. Okay, Your Lordship may kindly come to then that filed by respondent
Okay,
number 1.
additional affidavit, yes.
Yes, in para number, Your Lordship, para 2, Your Lordship.
There are two.
Yes. Your Lordship, the affidavit filed by respondent number 1, Your Lordship.
Yes.
The deponent most humbly submit that para 2 of the additional affidavit, the petitioner number 1 falsely stated that petitioner number 2 victim died his resident due to an ailment. Petitioner number 1 projected the death of the deceased victim as a natural death. However, it was in fact an unnatural death. Contrary to this claim, the deponent stated that on 4/11/2023, petitioner number 1 accused submitted a false information report to the officer in charge Yajuli, indicating that an unfortunate incident occurred around 6:30 p.m. at his parental house, where his wife was found hanging and discovered by his mother, Your Lordship. Following this report, the case was registered under Section 174 CRPC as UD case number so and so. An inquest was conducted by Executive Magistrate Dit Lower Subansri, who opined that the cause of death was hanging, choking. The postmortem report from Gyati Taka General Hospital 0 also indicated that the cause of death was hanging, with no evidence of foul play. Consequently, the investigation did not reveal any foul play and the case is being submitted as a final report. Now, what I'm trying to indicate, Your Lordship, they have not approached this court with this clean hand. He himself has reported the police that his wife is found to be dead, hanged, but he has filed an affidavit stating that she has died because of ailment.
Before this court.
Yes, Your Lordship. Your Lordship may find his affidavit, Your Lordship. In affidavit, Your Lordship, or not, Your Lordship. It is us who bring it into the record.
Oh, yes. Then this is liable to be dismissed on that ground only.
Yes, Your Lordship.
My
Because
lord,
we-
here, death certificate, this incident happened during the pending of this petition.
No, you have,
So
you have.
in
submit-
order to bring the record, in order to bring the death record, the applicant file additional affidavit showing the death certificate before the Honorable Court. Here, issuing authority retain the cause of death, exactly not showing the cause of death while hanging. The my learned person is not such a.
But you have
matter.
stated petition number 2 so and so, who was my wife, had expired on so and due to illness in my residence.
Yes, Your Lordship.
So,
At
So
birth,
this
in
is
fact-
a wrong statement.
this is after.
In fact, it's a perjury, Your Lordship. Extract
pending of
193.
their Petition. Anyhow, let the complainant may appear.
This is the thing, Your Lordship.
Moreover, the
affidavit also. In-
POCSO is not attracted. During the granting of bail by the
No,
special
no,
court
on
POCSO.
affidavit, you are saying something
Yes.
which
any-
is not,
any-
which appears to be contrary on the other materials on record. There are
uh,
materials which show that she died, she committed
Yes,
suicide.
suicide.
After
Every
that,
material I have annexed. all the
After that, the learned PP submitted a prayer.
Okay, we are
Thereafter-
not taking it up
Yes,
today.
yes. Finally, they are suicide.
Who is
Entire report
appearing,
is
who is appearing for,
also entire report is available before this Honorable Court.
who is appearing for the victim?
Your Lordship, it's a joint, they have filed a joint petition.
Oh, this is a joint petition.
Joint
But Your Lordship, it's-
victim and I am representing victim and accuser.
Then who will appear? Then
The complainant father is a complainant. The father is not present today.
father has been made party.
But yes, private respondent. The last occasion he was appeared.
When victim died during the pendency of this petition.
Yes, Your
Yes.
Lordship. And she was minor, Your Lordship, as on that, Your Lordship, if you see the record. And matter has been charge sheeted, Your Lordship. Earlier it was under investigation, now matter has been charge sheeted, Your Lordship.
Why 4 has not appeared today? Who appeared for 4 earlier? Have you taken steps for?
Last occasion, many occasion, private respondent has appeared. This is
But
long
there is-
pending,
there
this is
is
long
no-
pending case, my lord, long pending case. Many occasions private respondent has appeared.
But there is no indication in the order sheet. You are Mr. T. Torum
Yes, I am Tito.
and T. Ate only. No
One
mention.
friend, N. Tate was there,
Him?
N. Tate was there, who represent the private respondent.
No, your submission is not T. Torum, T. Ate. He has not appeared. It appears to be like
Not-
your
not,
affidavit
bring-
only.
Not brought on record, but many occasions he appeared. We personally recognize one another.
No, that is not enough.
So let me, in that case, I may be allowed to take a step on private respondent.
Because here there is a serious issue of your making statement on oath, false statement on oath, which may subject you to perjury. If ultimately this court comes to a finding that you have made a false issue, it will put you in trouble.
Yes.
Nabam Tate,
Yes,
he appeared in June 2023 once. Thereafter, he stopped appearing. Still heard Mr. T. Torum, learned counsel for the petitioners. Also heard Mr. T. Ate, learned additional public prosecutor. It appears that nobody has appeared for respondent number 4. It appears that nobody has appeared for respondent number 4. Though from the order sheet, it appears that Mr. Nabam Tate once had appeared earlier for respondent number 4. Learned counsel for the learned additional public prosecutor has pointed out that the petitioner number 1 has pointed out that the petitioner number 2, who is the victim in the instant case, has in the meanwhile passed away. Stop. However, he points out that in the additional affidavit filed by the petitioner number 1, there appears that a false statement has been made by the petitioner number 1 regarding the cause of death of the petitioner number 2, wherein it has been mentioned that the petitioner number 2 has died on 14/11/2023 due to illness at his residence. Learned additional public prosecutor submits that there are sufficient materials on record indicating that the petitioner number 2 died due by committing suicide and not for the reason as mentioned by petitioner number 1 in his additional affidavit. Stop. As the counsel for respondent number 4 is not present in the court today. This court is not inclined to take up the hearing of the matter today. Hence, let this matter be listed after 2 weeks on a date to be fixed by registry.
Yes, sir. Deeply obliged.
Item number 14 and 15. May I, Lordship? This interlocutory application 76.
76.
Yes, 2024 in IN number 73.
Yes, this
There
is,
is, in this case, Lordship, there is a mistake in typographic mistake in filing there. This application for condonation delay. In place of writing, Lordship, application under Section 5 of Limitation Act, application under Section 5 of CRPC was incorporated. That was the only single mistake. That is why, Lordship, Honorable Court has given a direction to that amended part, particular that in place. That is why I have filed this application for amendment of this, that defective part. That is why, Lordship, I am praying this, I may be allowed to correct the petition by this,
okay.
by writing.
Heard Mr. T. Tapa. Heard Mr. T. Tapa. You don't have any objection?
Regarding correction, no objection,
Correction.
Lordship.
Heard Mr. T. Tapa, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. This interlocutory application has been filed by the petitioner, Ms. Oped Jamo, praying for allowing the amendment of the title cause of the interlocutory application
Number 73.
number
I interlocutory application criminal 73 of 2024.
73
Yes, 73.
oblique 2024 as stop. Learned counsel for the petitioner applicant has submitted that due to inadvertent typographical mistake in the IA number, in the cause title of IA number 73/2024, the word application under section 5 of the CRPC 1973 has been incorporated in place of the application under section 5 of the Limitation Act 1963. As said, error is unintentional and had occurred only due to typographical mistake, inadvertent typographical mistake. Learned counsel for the petitioner prays for allowing the petitioner to correct the said mistake. The prayer is allowed. The how it will be corrected? By hands.
By
By
Let-
hand,
Yeah,
there is
by-
a bar actually.
For record, Your Lordship, this information system. So let them change the, your lordship,
First page.
first page.
I will
The-
do it.
If you can NIC record, your lordship.
Yes,
I will
the applicant is allowed to amend the said mistake by correcting the cause title of the interlocutory application number 73/2024. This interlocutory application is accordingly disposed of.
And with regard to the main IN number 73, this notice may be issued, lordship.
Only after
After
correction.
correction.
After correction.
So it,
Maybe list after a week.
This after week.
the, in the said, the I number 73 may be listed in this order itself before disposal. I number 73/2024 may be listed before this court after necessary correction after a week.
Deeply obliged.
Item number 21.
Yes, my lord. Item number 21, I'm for a petitioner hearing. May I, lordship?
What is this?
Lordship, here we are agreed by the judgment and decree passed by the Lanes CGM or Civil Judge Senior Division Capital Complaint. Lordship, here in the matter is like, if you no doubt the judgment is bulky, but lordship, we have paid the principal amount. The grievances before now is, lordship, the percentage, the interest which the Lanes Civil Judge has imposed upon us is exorbitant. That's it, yeah. By judgment and decree 3 of 2023 has page 18, lordship, I'll straight away take to page 23, lordship, that is the operative portion.
Page?
Yes, lordship. Page 23.
Just a minute. Yes. Yes.
Lordship, here in, may I read, lordship, the last paragraph, the order says, Lord, that is the operative portion. In the result, the instant money suit is decreed in favor of the plaintiff, that is the respondent, with a cost of rupees 10,000. Accordingly, defendant is directed to pay a sum, to pay rupees 61 lakhs only to the plaintiff with interest rate of 3.5 per month on the principal sum from January 2019 till the date of filing of the suit, with interest rate at a rate of 6% per annum on the principal amount, sum adjust from the date of suit to the date of decree, with future interest at the rate of 6% per annum from the date of decree to the date of payment. Lordship, what has happened in this matter is money suit was filed by the.
You are agreed by which portion?
We are agreed by lordship. The interest rate 3% on the principal from January 2019 till the decreed amount, till the filing of the suit.
No, I have not understood this. 61 lakh only to the plaintiff with interest at the rate of 3.5% per month on the principal sum from
January 2019 till the date of filing of the suit. From when?
what happened on January 2019?
Lordship, on January 2019, we had made a promissory note that said, I'll pay the loan amount which I have taken from the respondent, that is the plaintiff.
At what rate?
It was given 3.5%.
per month.
per month.
So
Lordship-
judgment has reiterated the condition of the promissory note.
Yes, Lord. Lordship, we have to see this laws in this matter, whether that loan amount was a commercial transaction or not, Lordship. That has to be, each and everything has to be seen, Lordship, why the 3.5%, whether the respondent, that is the plaintiff.
But that was agreed between the parties.
Yes, Lordship.
On
Lordship-
what ground you are assailing? What is your ground?
Lordship, that promissory note, the judgment was filed on our admission on order 12 rule 6, which we have,
You
Which-
admitted that.
which we have denied the Lordship, the interest part. We have said we executed a promissory note, but the,
CPC. Yes.
but the interest part, we have not agreed to that. Lordship, what has happened in this matter? The, before that, Lordship, I'll come to the, may I come to the facts of the case, Lord? In the nutshell, Lordship, here what has happened, that is a appellant, this defendant in there was heading a village community that is, shared to Pen council. He was the head of a council, and we had approached the plaintiff. Since Lordship, our village was getting a land compensation from the army. And Lordship, we had engaged him as our counsel, and during that course of time, Lordship, 58 crore was paid by the government of India
To
to that land compensation people of Rupa area. So which I was spearheading as a head, I was leading that community. And Lordship, and during that period, like what I had, that money which I had taken a loan from the plaintiff, that is the respondent, that I had 1 crore 70 lakhs. That amount which was correct.
today,
Yes, Lordship.
you have to narrate the story properly.
Okay, Lordship. Lordship, in that way, Lordship, a money suit was filed by the plaintiff claiming a sum of rupees.
You were the defendant.
I was the defendant, Lordship.
Okay.
The plaintiff had filed a money suit which was number 84 of 2022 before the civil judge, senior division, Capital Complex, UPR. Had a claim amount of 3 crore 26 lakhs 80,000 from.
Money suit was filed for recovery of what amount?
3 crore 26 lakhs 80,000
From you.
from me, Lord.
On what count? What was the claim?
On the
what
claim,
basis?
on the claim that 3 crore was include, I had taken a loan from him, a sum of 1 crore 70 lakhs.
Who is this person who can give? This is a private person.
Yes, Lordship, he's a private person. He's a
He
advocate.
gave you loan of 1 crore.
1 crore 70 lakhs, Lordship. He has not given me, Lordship, that was his amount which as in like after getting a compensation, we were supposed to pay to him. Lordship, I was a chairman of a group of villager, that is Tukfen Village Council. It's a community consisting of 14 villages. Like our land was not given compensation by the army. So to get that compensation, Lordship, we have engaged the respondent, that is the plaintiff. And during course of time, Lordship, like out of
Who is the respondent? Why have you engaged him?
Lordship, since he is by profession, he's an advocate.
He's a lawyer.
Yes, lawyer.
And this 1 crore 7 is the fees.
That was the percentage, Lordship. We had agreed that if we get this much amount, some percentage will be given to him.
That percentage come to 1 crore 7 lakh.
Yes, 71 lakhs, 1 crore 70 lakhs.
Okay.
So like Lordship, when the amount was transferred in the name of that community, and the amount which the respondent was supposed to get, so I took since we are a friend, I had taken a loan from him, not from directly from him. I've taken that amount from that our community. Meaning thereby, Lordship, that amount was never taken from him, but since an agreed between us, said this will be a percentage from the land compensation.
How can you take percentage?
Yes, Lordship.
How can you take percentage from the?
Percentage, Lordship, I have not taken. That was I had categorically made statement in my written statement also that 17 crore was paid to our community, since I was the chairman of that community, Lordship.
Land was acquired by army,
Yes, Lordship.
acquired by government,
Acquired by the army.
whether it was acquired or it is for some other purpose.
It was acquired by the army, and they were already residing there since the year 1962, Lordship. They have not paid us compensation. For that reason, Lordship, since compensation not being paid to our community, so like the village council has engaged, they had appointed me as the chairman of that village council, consisting of 14 villages.
Okay. Thereafter, what happened?
Then thereafter, Lordship, there was 17 crore was given to our community, to our people of Rupa. From our 17 crore, Lordship, that 1.1 crore 70 lakhs was the percentage as we have we have decided to give it to the respondent. And Lordship, that accordingly, Lordship, since we are a friend, so I had taken that loan amount from that community in his name, Lordship. That was supposed to be paid to the respondent. So Lordship, as such, Lordship, since I couldn't pay the amount, 1 crore in the time as agreed between me and the respondent. And thereafter, Lordship, a promissory note was executed between me and the respondent. And Lordship, before filing of this money suit, I had already paid him 1 crore 9 lakhs. So accordingly, Lordship, since I had paid him already 1 crore 9 lakhs, in my written statement, I have partially admitted and partially denied. I have admitted that I have taken a sum of rupees 1 crore 70 lakhs from the respondent, and a sum of rupees 1 crore 9 lakhs was already paid to him before filing of the money suit. So on that filing of my, in my written statement, since I have admitted partly.
This amount was decreed on admission.
Yes, Lordship.
Then I have to go through the facts because it raises doubt.
In our WS also, Lordship, we have admitted partly and partly denied. Since I have admitted saying I have taken a loan of 1 crore 70 lakhs from the respondent, and I have admitted.
But you have not actually not taken any loan from the
Not any loan from him. That was I have categorically made in my WS also, that amount was the compensation amount given to my village community, consisting of 14 villages.
My lord, after the judgment and decree, the appellant, who is the judgment debtor, he has paid the principal sum of rupees 61 lakhs.
No, what is the story? You tell.
Now, my lord, the only issue which is alive is whether the pre-suit interest of 3.5% per month as awarded by.
Now, what was the basis for that?
1.70.
No, this decree passed in this money suit.
Money suit. It was a decree on admission.
And on what basis the plaintiff claimed?
My claim was on the basis
On
of
promissory note.
Promissory note. That
But he says that actually there was no such loan, never such loan was.
No, there was nothing in the, no whisper in the entire written statement. That promissory note, my lord, will find at page number 44.
Lordship, in that way, let us go to our WS, Lordship. Here I have made a categorically in my Lordship, the page 58, my written statement. paragraph 2, Lordship. Here also I have a may I read on
Page,
page 5858, Lordship. That was my written statement before the senior. What is page 58, Lordship?
yes.
May I read on? That with regard to the statement in paragraph number 2 of the plan, the answering defendant partly admit and partly deny. The defendant being the chairman of Dukpen Village Council, here refers as so and so, being the apex body of say Dukpen community consisting of 14 villages, was given in charge of the land compensation demand by the people of Rupa for the land occupied by Indian Army and Border Road Organization, without paying land compensation to the indigenous people of the area. As such, had engaged the plaintiff, that is the respondent, as their counsel for the grievance to be addressed by the government of India. During course of time, the government of India released the compensation amount of 57 crore, out of which 17 crore was given to TVC, that is to our village, against the 61 acres of land in Rupa and Gachman area. So the legal fees amount as per proposal was to be transferred directly into the account of the plaintiff. Here also, Lordship, I have said that amount
Where is that promissory note?
promissory
No,
note.
it says that for facilitating the villagers to get their due compensation from the army, the plaintiff was engaged as a lawyer.
Yes, Lordship. That
And against that, he has to be given certain fees. And that fees has to go directly into his account.
yes, that directly going into instead of that into the plaintiff, the respondent, and I had taken a loan. That amount I had took a loan from him, Lordship. That I admit to it.
When the amount
But
was
actually,
released,
no loan was taken.
when the amount was released by the government of India, the amount was deposited in their account.
In the account of the
Village community.
Now, out of that account, out of that
No,
account,
let me understand. The compensation amount was credited in the account of the villagers whose land have been acquired.
Yes.
Individual villagers.
No, a committee was constituted. He was the chairman of that committee.
Oh,
Now,
this is a blunder.
Out of that amount, I was entitled to 1.70 crores. Now, instead of transferring that amount,
Where is that basis that you were entitled to 1.70?
there was no written agreement.
What is the basis of that?
I'm coming to that. Now, instead of transferring that amount to my
No,
account,
before you transfer that amount, you have to satisfy that the court, that where is the basis, that on what basis that agreement was, that any such agreement existed.
in the written statement, they have admitted that there was an agreement with such effect.
That is the oral agreement.
Yes, oral agreement. Subsequent, that amount was to be transferred in my account. He being the chairman approached me for loan. Accordingly, I consented that amount, instead of being transferred in my account, should be transferred in his account. Accordingly, that amount was paid to him. Now, subsequently, when he failed to return that amount, he executed a promissory note. That is how I filed the money suit.
Where is the judgment of the trial court?
The page 18, Lordship.
The money belongs to the villagers.
Villagers.
Money belongs to the villagers. It never went into the account of villagers. It went directly to the account of chairman of the TVC.
Not easily. The account of TVC. That is a committee constituted by the villagers. So apportionment, it is their job. that awardment, my lord, will find at page number 28, paragraph 4 of the plaintiff. Page 28.
Yes.
28. Yeah. Paragraph 4, that the defendant promised to return the aforesaid amount within 31/12/2018, since the defendant and the plaintiff are long acquaintance and being assured of refund of the
No,
paper.
okay, let me understand. What was the percentage? What was the basis that so much of money should go to the plaintiff? What was the agreement?
Agreement, my lord, 30% of the total
Ah.
amount mentioned by the government.
Was it legal?
Well, that is another aspect.
That aspect is important because you are giving a color of once you get a decree of the court, it gets legal sanction, even if originally it was not legal. Now, whether to that question, this court can go into in the regular first appeal.
To my humble understanding, my lord, the issue which is alive today is the 3.5% interest, because in terms of the decree.
No, but while considering the suit, it comes to the notice of the court that the basis is not legal. Then then what course this court should take in a civil suit? Answer my query. We are not taking it up today. We are deferring it to some other day. Because from you, what I have understood, the money should go to the villagers whose land was acquired. But there was an agreement between the council and the chairman of the village council that this much percentage will be given. That too an oral agreement. That basis is questionable, first of all. Then what happened? You filed a suit. Then the present appellant took loan on paper. That was not actual loan, because money was neither your money was to be paid by the government of India to the villagers. But to take your share, you entered into an agreement that let the money be deposited to your account because you are villager, I am not a villager. And from that, my 30% should be paid. And till then, I will show that that amount is given to you as a loan.
No, my lord, that's not the correct fact.
Then
Correct fact, my lord. The committee which was constituted was authorized by the villagers to choose any person to represent their cause. Accordingly, this committee chose me
okay.
on a condition that I would get 30% of the whatever amount is released by the government of India. Now, after release of this amount, from the government of India, this amount was deposited in the account of the committee. So this committee, as per the agreement, was to release this 30% in my account. But in the meantime, the appellant approached me for loan, and I agreed to give him the loan. My entitlement was given to him as loan. That is it. Now, when he failed to repay the loan, he executed the promissory note. And it is on the basis of that promissory note I have filed this suit.
promissory note is at 44A.
44, 44 in type copies and 44.
And as there was an admission decree, the court did not went into these questions regarding
No, these questions were not raised.
not raised because it was an admission decree. Now many questions, if it comes to the for the appellate court, whether appellate court can go into those questions which was not raised before the trial court. Because by the admission decree, now whether by the admission decree this promissory note of 1,70 lakhs was given a seal of approval
Yes. And
without going into fact that whether actually he had taken an amount of rupees 170 crores from
from the
the
plaintiff,
from the plaintiff or not.
because in their written statement, they had categorically admitted that he had taken 1.7 crore rupees on loan from the plaintiff.
But that is not a fact. You only promised to give whatever was entitled to you as per the agreement. The money never came to your account. Neither it was transferred to his account by you.
It was not transferred to his account by me, but on my instruction, it was directly transferred to his account.
No, otherwise also money would have come to the account of the villagers only by the government of India.
No, madam, it came to the account of the committee.
Committee.
And committee was given the task of apportionment of that amount between the villages.
Then committee transferred this amount to,
On my instruction, committee transferred this amount into his account, the account of the appellant.
because of this promissory note.
This was subsequent promissory note. When he failed to repay that amount to me, then
Now,
he-
why you asked to transfer the amount to his account?
because he approached me for loan. He was running a hydroelectric project.
Okay.
For that, he needed.
So
money.
you want to say that this amount was utilized by him?
Yes,
Or,
sir. Yes, sir.
okay.
That is why, my lord, I was submitting that in terms of that decree, my lord, the principal amount, that is 61 lakhs, he has already paid.
Okay.
Now, the only issue which remains alive is as to whether the pre-suit interest of 3.5% per month as decreed by the learned trial court is correct or not.
Yes.
That is the only issue, because he has accepted the decree.
Lordship, we have challenged the or admission on basis the lower court has passed on admission the judgment. That also we have challenged the Lordship. Why? Because Lordship, we have partly admit, partly denied. We have not denied the entire, when on order 12 rule 6 says that when you admit, everything has to be clear and there has to be no ambiguous and all that, since we have partly admit, partly denied. We have not agreed that we'll pay 3.5% to the plaintiff. The lower court ought to have gone through the promissory note, and whether the promissory note was taken forceful or whether that was taken was given voluntarily by the
Whether this
appellant.
please you have taken in your written statement.
That we have not taken, but
They-
we have only denied that 3.5, we have denied the interest part also.
Now, where is that denial?
Lordship,
is-
coming to my
3.5% interest.
page 56 is my Lordship,
You,
WS.
you come to directly to my query.
Yes, Lordship.
Where is that denial that you have not taken?
Lordship, in our entire petition, we have regard to
Yes,
Lordship, in my entire like WS, I have partly admit, partly denied. So with regard to the statement, which
no, now you are assailing only that portion of interest which was before filing of the suit. From the date of promissory note till the filing of the plaint, 3.5%, that you are challenging. Where have you denied? Or you come prepared?
Oh, Lordship, Lordship, in my entire WS, I have partly admit, partly denied. So right from one Lordship, page 58.
No, you know that denial cannot be evasive denial.
That
You have to clearly deny. Where have you denied? We are not taking it up today. Let him come prepared. You come prepared. You seems not to be in full flow today.
Lordship, in my entire WS, I have partly denied. I have not like
No, whether that denial is sufficient, partly denied.
that is since Lordship, I have
What CPC says, your denial has to be specific denial. If you are admitting that the denial is evasive, then we'll dismiss the suit. Dismiss the appeal.
In fact, there was no evasive denial also. There was specific admission in fact.
Next week. And Mr. V. Jamo, learned counsel for the appellant, also heard Mr. H.K. Jamo.
No, RN
R. Rinchen Ledo, Thongon.
Yes, ma'am.
R. L. Thongon, learned counsel for the appellant. Learned counsel for the appellant. During the course of the hearing, learned counsel for the appellant had prayed for some time for responding to the queries raised by this court. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by. When?
I'm okay with any date.
any date, Lordship, not
Next week on a, after 2 weeks on a date to be fixed by registry.
Item number 23.
Yes,
Right,
what is
Lordship.
this?
Lordship, this is a make appeal.
You are ready?
Yes, sir.
Ready? Yes.
My lord, here I'm challenging the quantum of compensation. Against-
Quantum,
Yes, my lord. Against the judgment and order passed by the learned.
you are the claimant.
Yes, my lord, I'm for the insurance.
You are
company.
for enhancement.
Insurance company,
You are in insurance company.
insurance, yes. I'm the appellant.
I'm for the plan.
Okay. What was the amount
Amount, my lord,
awarded?
amount, my lord, it's 23 lakhs 4,390.
Yes.
My lord, there is no dispute with regard to the accident, death of the deceased in the accident and the liability of the insurer. My lord, our ground only here is since the claim has been filed by the elder brother of the deceased, who is 85 years old and has independent source of income, is not entitled to compensation under the head loss of dependence.
Okay. The claimant was only the elder brother. Only one claimant was there.
No, my lord. In fact, my lord, the first claimant was the younger brother of the deceased. Then after that, he expired. And after that, my lord, the present claimant was substituted.
Whether the awarded amount has been paid,
No, my lord.
how much has been paid?
My lord, we have not paid the amount.
Nothing has been paid. No, not even a percentage of the awarded amount.
No, my lord.
There has been a stay
Yes, my lord.
by this court.
Yes.
Okay. Last year award was passed. Okay. What is your submissions? Make some.
My lord, my contention is that the claimant is entitled to compensation under the head loss of state.
Loss of
Loss of state, my lord.
what percentage?
My lord, there's a different calculation for loss of state and loss of dependency. Here, my lord, the claimant is not defendant of the deceased. Hence, is not entitled to compensation under the head loss of dependency. This is the case. my lord.
How much was calculated under the head loss of dependency?
My lord, loss of dependency comes to around 40 lakhs. Well, the award is 23 lakhs. Along with interest, it comes to around 40. And under the head loss of state, the calculation comes to around 20 lakhs. My lord, I've relied on a judgment of our own High Court. I think a copy I've given it last time. Is it the lordship? Case of Folia Kothar. My lord, in this case also, the elder brother of the deceased had filed.
No, there was a evidence on record to show that the elder brother was not dependent on your income.
My lord, they have not produced any evidence of to show that the elder
He
brother
was dependent.
defendant.
Yes.
That's my case, my lord.
So how much it comes? What should be the percentage of loss of?
My lord, our calculation comes to around 20 lakhs, 86.
What is the calculation?
Under the head loss of state.
No, no. Oh, loss of estate has to be calculated at the rate of 25%.
Yes,
At what percentage? Apart from this judgment, you are relying on any other judgment?
my
To
lord,
show.
my lord, one more judgment. This is Manjura Bera, where the daughter had filed for compensation. And the apex court has held that daughters, they are entitled to compensation. Here also they are under the head loss of state,
But this
not under
one,
the head loss of dependency.
yes. Regarding other computation of annual income of the petitioner,
No, my lord, there is no dispute.
there is no-
It's only on loss of state and loss of dependency. And my lord, I can give the calculation how is loss of dependency and loss of state.
you have,
No, my lord, I can write it down in this,
okay.
how to calculate a loss of dependency and
As per your submission, what would be the, how the compensation would be computed? Give a calculation.
yes.
What is your submission?
Lordship has to say only whether the claimant is entitled to compensation under the head loss of state or.
And your submission is as because there is no evidence on record regarding loss of dependency.
Yes, my lord.
Therefore,
Is that entitled to
he cannot be
compensation?
regarded as a dependent of the deceased.
Yes, my lord.
And therefore, being brother of the deceased, he is entitled only to loss of estate,
Yes,
not loss of dependence.
dependency, yes.
Yes, what is your submission?
My place was. My lord, before coming to my lord, the aspect which is submitted by my learned friend, my lord, I would like to, my lord, point out some paragraphs from the impugned, my lord, award,
Impugned judgment.
impugned award, my lord. This is more motor accident crime tribunal, my lord.
Yes.
Impugned award, my lord, which is necessary for adjudication of this MSCT appeal, my lord. My lord, the deceased was died in a motor accident, a vehicular motor accident, my lord.
They are
On my
not
lord-
disputing.
Yes, ma'am. Thereafter, my lord, this claim petition, ma'am, is originally filed by the younger brother of the deceased, my lord. During the pendency of, my lord, this claim petition, this younger brother of deceased was also expired. Thereafter, my lord, present claimant was substituted as a claimant, my lord. And that has not been objected by the, my lord, the appellant herein, my lord. Therefore, he was substituted. Thereafter, my lord, on the basis of, my lord, pleadings of the parties, my lord, certain, my lord, issues has been framed by the learned tribunal. My lord. May I take your lordship to the issues framed by the learned tribunal, my lord, in the impugned judgment, my lord.
Page.
Yes, my lord. Yes, my lord. Page 25. ma'am.
25 of.
25 of this, my lord, this appeal petition, man. Page 25 to 5. Paragraph 21, man. Points for determination.
Yes.
Have you got
Yes,
Points for determination. Married one.
yes.
On the above pleadings of the claimant and the opposite party number one, the following issues were framed on 6/5/2022. They are: one, whether late such and such died as a result of injuries sustained by him in the road accident that such and such involved Tata truck bearing registration upon such and such. Therefore, issue number two, whether the accident took place due to rash and negligent driving of the driver of the offending vehicle. Thereafter, my lord, third issue, whether claimant is entitled to receive any compensation, and if yes, to what extent and what amongst the opposite person will be liable to pay the compensation. Since, my lord, they are not disputing regarding this issue number 1 and 2, my lord, will confine to issue number 3, my lord. Well, I will cut it short, my lord. Thereafter, my lord, may I take your lordship to the page number, my lord. Page number. Yes, ma'am. Page number 41.
Page number
41. Page number 41. My lord, I'm sorry, madam, before that, page 40, my lord.
page
Page 40, ma'am. Page 40.
40.
40, ma'am.
Yes.
That's regarding issue number 3, my lord. 72, my lord. There are 72. Now, to answer the third point of determination is to whether the claimant is entitled to receive any compensation, and if yes, to what extent and who amongst the opposite parties will liable to pay the compensation. We see that the opposite party has objected on the entitlement of the present claimant on claiming the compensation. It is observed that initially the claim application was filed by the then claimant late such and such, who during the pendency of the case expired. So on the strength of succession certificate, the present claimant Sri such and such filed application before the court with prayer to allow him to substitute him. It is worth mentioning here that the former claimants that such and such obtained certificate about debt and securities of the deceased such and such on such and such exhibited as paper exhibit 7, and later the present claimants such and such obtained succession certificate about the death and secretary of late such and such by order numbers such and such. And basing on the succession certificate, the claimant such and such prior to be allowed to substitute former claimant death such and such, to which the opposite party did not object, and hence he was suspended by such and such. Thereafter, my lord, I will skip 75, my lord. It's not 7. Then 76, my lord. Sections 166, 1D of MB Act state that an application for compensation arising out of an accident of the nature specified in subsection 1 of section 165 may be made, where that is resulted from the accident by or any of all or any of the legal representative of the deceased man. Therefore, 77. The definition of legal representative have been given in section 2, subsection 11 of the CPC, which is reproduced herein below. My lord, they have not disputing in this point, my lord. I will, my lord, not bother your lordship to this issue, my lord. Now, my lord, on 78th, they have the learned tribunal has said. So the past part of the third point for determine is answered in positive and held that the claimant is entitled to receive the compensation, my lord. That's past part. Thereafter, my lord, now, my lord, 79, my lord, they have not raised this objection, so therefore I will not read this 79, my lord. Although, my lord, this is held, they have taken, my lord, some objection regarding, my lord, driving license of the, my lord, who is driving the truck, my lord, which is involved in the accident, my lord. They have said that the driving license of the truck driver is fake, my lord. I will not, my lord, go to that and my lord. Now, my lord, now, my lord, second part, whether what will be the amount of compensation, my lord. That is at page 42, my lord, paragraph 80, my lord. My lord, as your lordship knows, my lord, in this Sarla Verma versus Delhi Transport, yes, which is reported in my lord, this reported in my lord. Two thousand nine six SC, my lord, 121. This is, my lord, Supreme today, my lord. My lord, paragraphs will be little different, my lord. My lord, in paragraph 82 also, my lord, it was specifically mentioned by the learned tribunal, my lord. How compensation should be assessed, my lord. 82, my lord. The Honorable Supreme Court, in the case of Sarla Verma versus in others versus Delhi Transport Corporation in other, reported in such and such, laid down the principle and criterion for assessing compensation in case of death. First, my lord, age of the deceased. Second, my lord, income of the deceased. And third is the number of dependents. My lord, first, my lord, this age of deceased, they are not disputing, my lord. So, my lord, I will not worry your lordship to that point, my lord. Second, my lord, income of the deceased, my lord. My lord, when this, my lord, accident was, my lord, happened, my lord, disease was serving as an peon, my lord, and he was earning, my lord, good sum of.
They are
They are not
disputing,
disputing. my
not
lord.
disputing.
Regarding this last, my lord, number of dependents, my lord, in my humble submission, I would say, my lord, this my lord, match appeal, is misconceived, my lord. They have misconceived this mission. My lord, if we see the quantum of this compensation, my lord, oh, my lord, no compensation was given on the basis of loss of dependency, my lord. Kindly see, my lord, Sarla Verma case, my lord. What it says, my lord, I just, my lord, page 7, my lord. Page 7, my lord.
7,
Yes, my lord.
yes.
Page 7, my lord, paragraph 12. My lord. We have already noticed that the personal and living expenses of deceased should be deducted from the income to arrive at. Sorry. Yes, ma'am. Arrive at contribution of to the account. No evidence need to be laid to show the actual expense. In fact, in any evidence in that we have will be wholly verifiable and likely to be unreliable. Claimant will have obviously tend to claim that the disease was very fungal and did not have any expensive habit and was spending virtually the entire income on family. In some cases, it may be so. No claimant will admit that the disease was spendthrift even if he was one. This is very difficult for the respondent in a claim petition to produce evidence so that this was spending a considerable part of income and himself, or that he was contributing only a small part of income on his family. Therefore, it becomes necessary to standardize the deduction to be made under the head of personal living and living expenses of the deceased. This leads to practice of deducting to our personal and living expenses of deceased. My lord, this point is important, my lord. 1/3 of income if deceased was married, and 1/2 of income if the deceased was a bachelor. This practice was evolved out of experience, logic, and convenience. In fact, 1/3 deduction got statutory recognition under the second schedule of the Act in respect of claim under section 1763A of the MB Act 1988. Thereafter, my lord, I'll come to Ms. Paragraph 14, my lord. Though in some cases, the deduction to be made toward a personal living and living expenses is calculated on the basis of unit indicated in the Trilok Chand The general practice is to apply standardized deductions. And having considered several subsequent decisions of this court, we are of view that where the deceased was married, the deduction for personal living expenses of the deceased could be 1/3. Where the number of dependent family member is 2 to 3, 1/4. Where the number of dependent family member is 4 to 6, and 4 to 6, and 1/5, where the number of dependent family members exceeds 6. Now, my lord, in this case, my lord, since my lord, this deceased was a bachelor man, bachelor man, therefore, my lord, 50% was deducted from his, my lord, say, my lord, compensation, the total compensation which is arrived with by the landed tribunal, my lord, out of that, 50% has been deducted, since there is no any dependent. Had there, my lord, in my humble submission, what I like to say, had, my lord, any, my lord, compensation has been given to me in the head of loss of dependency, my lord, it should be, my lord, 1/3, or it should be, my lord, 1/4, or it should be, my lord, 1/5, like that. Since he has no dependents, my lord, therefore, my 50% has been, my lord, deducted from the compensation which is arrived by the landed tribunal. Kindly see, my lord, this page 43, my lord. Page 43, paragraph 85. Page 43, my lord, 43. Paragraph 85, man. As per the multipliers indicated in generally accepted from the case of Trilok Chand, reported in such and such for claim under section 166 of MBA, if the age of victim is 46 years but not exceeding 50 years, then a multiplier of 13 has to be applied. Therefore, the loss of work out to be rupees to 2,100 or 21,493. This is the, my lord, salary, gross salary of the deceased, which was calculated, my lord. Multiply by 13, my lord, as said in Trilok Chand, my lord, since his age is, my lord, above 46, my lord, but not exceeding 50 years, 48, during the time of incident, he was 40 years, 48 years. There, 13 into 12, that amounts to, my lord, 33,52,908. This is annually, my lord. This is the calculation which is, my lord, which was come up by this tribunal, my lord. As the deceased was assumed to be single, my lord, in absence of mention of wife and children in the claim application, so the 50% of his income is deducted as personal and living expenses. Hence, 50%, that is from total of 33,52,908, 50% has been deducted. Then comes to, my lord, 16,76,454 rupees, my lord. This was the, my lord, final award, my lord, final compensation, which was come up by this landed tribunal, my lord. So,
How the claimant would suffer that pecuniary loss if he is not a dependent?
My lord, since he is a legal here, my lord, he is a legal here. My lord,
So your submission is
yes, my lord,
that even if there no loss of dependency,
yes, my lord, compensation can be given to his, my lord, legal representative, my lord.
against which head?
Against,
Loss of pecuniary,
under the laws of pecuniary, my lord, as said in Sarla Verma case, my lord.
where?
In Sarla Verma case, my lord. My lord, page 6, paragraph 9. Paragraph 9. Basically, only 3 facts needs to be established by the claimant for assessing compensation in the case of death. My lord, I will submit that, my lord. There is no any such, my lord, that's loss of estate or loss of dependency, my lord. There are 3, my lord, factors, my lord, which we will consider for giving the compensation, my lord. First, age of the deceased. Second, income of the deceased. And third, the number of dependents. In this case, my lord, since there is no any dependence, therefore 50%, my lord, of the pecuniary loss, which is incurred by the, my lord, deceased, has been deducted, my lord. In my humble submission, my lord, in my humble understanding, my lord, loss of dependency and loss of estate, my lord, I think there is no such a formula, my lord, which is formulated by Honorable Supreme Court, my lord. In terms of this Sarla Verma case, my lord, this is the formula which has to be formulated, my lord.
What is your name? What is your name?
Jika.
Mr. Kato, can you bring an authority to show that unless there is a loss of dependency, compensation may not be awarded to a
Yes, my lord, in
dependent?
Sarla Verma case.
You have counter to his submission. Yeah, you can, his submission is that even if there is no loss of dependency, if you are a legal representative.
My lord, we are not disputing regarding the legal representative.
They're not disputing. Therefore, I am not submitting on
Of
that.
course,
my lord.
they are entitled to compensation, but only the head. Under the head loss of state, not under loss of dependency.
No, what I am seeking is, apart from this judgment of the coordinate bench, any other authority which shows that if there is no loss of dependency, because in this impugn judgment, the quantum of 16 lakh has been shown as pecuniary loss.
Yes, ma'am.
It does not mention loss of dependency.
No, my lord, if you see the calculation properly. My lord, please come to page number 44.
Yes.
44, my lord, 30% future prospect has been deducted. So under loss of dependency, my lord, 30% future prospect is added.
No, the judgment does not mention specifically.
No, my lord, it does not mention specifically, but it has been awarded under head loss of dependency. Because by going through the calculation.
My lord, with all due respect, ma'am. When this,
My lord, loss of dependency.
I'm just interfering you.
My lord,
I'll hear you.
I'm sorry, my lord, loss of dependency is the amount spent by the deceased on the dependents. And loss of state is the sum total
Which he will
amount
inherit.
paid, which the deceased will be saving for himself. That is, it comes
Only
to
that-
25%.
That will be inherited by the
Yes, that will be
legal
inherited by the
representative.
legal heir of or legal representative of the deceased who is not dependent.
So your submission is that calculation of pecuniary loss at the rate of 16 lakh was wrong by the
Yes,
tribunal. The calculation ought to have been on the basis of loss of estate,
state, yes.
whereas no such calculation has been made by the tribunal in this case.
Yes, madam. Well, the amount,
Okay, let
by
me
seeing
hear-
the amount also it will
Let me,
awarded under loss of dependency.
no, how you can say so when the judgment is not saying it clearly? Under what head? It has not mentioned that this amount is under loss of dependency.
My lord, but the calculation itself it shows, I can show, my lord, the calculation. How the calculation is made in the loss of,
No, you show it while answering to his, while replying to his submission.
my lord, even in Sarla Verma also, my friend has been referring, the case also, it has been awarded under a loss of dependence. But
Where?
It has been filed by the widow and 3 minor children.
No, I want, where is the clearly where it has been clearly reflected in the judgment regarding loss of dependency. Let him make you submit, make your, complete your submission.
Yes. My lord, with all due respect, man. When this, my lord, the judgment.
Now,
Yes,
now,
ma'am.
my
Yes, ma'am.
understanding is
Yes, ma'am.
you are compensated only to the extent of loss suffered by you.
Yes, ma'am.
Loss may be loss of dependency, loss of estate, loss of filial consortium.
Yes, ma'am.
There has to be some loss which is required to be compensated.
Yes, ma'am.
Here, the pecuniary loss, it is what kind of loss?
My
Is
lord.
it loss of estate or loss of dependency?
My lord, in my humble submission, my lord, I will say, my lord, in my humble submission, my lord, in my humble understanding, I will say, my lord, in Sarla Verma case, my lord, it has been, my lord, given, my lord, how it should be calculated, my lord. There is no, my lord, in my humble, I may be wrong, man, but there is no any, my lord, formula like loss of dependency or law, because, my lord, if I come to Sarla Verma case, my lord, the start point, my lord, number of dependents, number of dependents, that is there, my lord. If number of dependents is, my lord, it said, my lord, if this disease is bachelor, my lord, 50% will be deducted from his, my lord, from the, my lord, the award which was finalized by the tribunal. Thereafter, my lord, if he has any dependency, my lord, then my deduction will be less, my lord. Suppose, my lord, one third of 100% will be, my lord.
No,
yes.
that is for
Yes, ma'am.
computing his income.
Yes, my lord.
That deduction is for the purpose of computing his income. What would be his income?
Yes, ma'am.
Then after you compute the income, you will employ this multiplier formula.
Yes, my lord. That's true, my lord. That's why, my lord. If my lord, in this case, my lord, in instance, my lord, had it been my loss, any, my lord, any award is given to me under the head of loss of dependency, my lord. My lord, the calculation of 50% which was deducted, my lord, it shouldn't be. It should be either one third. It should be either 1/4. It should be either, my lord, 1/5 or, my lord.
No, why? Because he was bachelor, therefore 50% was deducted.
Yes, my lord. Therefore, my dependency, my lord, under head of dependency, no, my lord, award has been given.
Under which head the award was given?
Because of this, my lord, pecuniary loss, which is because, my lord.
No, how you will suffer pecuniary loss?
My lord,
You will suffer loss because on his death, you would have inherited certain things.
Yeah, my lord.
That is lot of estate.
Yes, my lord.
Or you would have suffered loss if otherwise you were his dependent.
Yes, my lord.
But because the earning member died, you lost that amount. That is loss of dependency.
Yes, my lord.
In this, and for getting the award against loss of dependency, you have to prove that you were dependent. In this case, you are saying you were not dependent on your brother.
Yes, my lord.
So against which head the compensate you will get compensation only with regard to some loss suffered by you.
Yes,
You will not get compensation merely because you are legal representative.
Yes,
Legal representative may file a claim case.
Yes, my lord.
But who will get?
Yes,
you make me understand on these
Yes,
queries.
yes, yes.
Who will get the claim would be ascertained if whether you have suffered any loss or not. Unless you suffer a loss, where is the question of getting compensation?
Yes, ma'am.
That is his submission also, that in this case, you have suffered loss of estate. You have not suffered loss of dependency. Therefore, the tribunal was wrong in awarding you compensation for pecuniary loss, not mentioning their loss of dependency.
Yes, ma'am. My lord, kindly see, my lord, this while calculating this, my lord, award, my lord, the salary of the deceased my lord has been taken into consideration. Salary, my lord, in my humble submission, my lord, is also amount to a state, my lord, state of the deceased, my lord, which, my lord, would he have been alive, my lord, he have been earned till he reaches the age of retirement or otherwise. This salary has been, my lord, taken into consideration, which was earning by the deceased at the time, before the time of that incident, my lord. And in my humble submission, my lord, this salary is also an statement. Because, my lord, when my lord, this salary has been, my lord, to say it is in the state, my lord, it will accrue with time, my lord. It will accumulate to the person, my lord, with time, my lord, because my saving account, like my saving, my lord, is if we deduct, my lord, suppose my salary is 40,000, 50% is deducted is my personal expenses, my lord. That's 20,000. It will go as my saving, my lord. And that will become my statement. In other words, in humble submission, that will go as an state, my lord. This is saving, my lord, which will save
On
by the.
what basis 25% was given as loss of state? Your submission is that 25% should be given
Yes, ma'am.
as loss of estate. On what basis that percentage is computed? Why not the entire? Because you are the only representative. After deducting personal expenses, whatever remains, why not the entire?
No matter, this 50% income deduction also is a calculation based on loss of dependency. On this only 50% is deducted.
Okay.
So through this calculation also, my lord, it can be seen that the learned tribunals awarded under the head loss of dependency. Because in this case, my lord, here.
No, that was not my question. Your submission was, as there is no loss of dependency,
Yes, madam.
therefore against that head, they should not be given any, the claimant should not be given any compensation.
No, my lord. My submission is not that they are not entitled to
No,
compensation. They are entitled.
you listen to my query carefully. Your submission, as I understand, is that as the claimant has not suffered any loss of dependency, as because he was not dependent on the deceased, therefore he should not be given any compensation against loss of dependency head. Being a legal representative, he is entitled only to loss of estate, compensation against loss of estate, what he would have inherited. Now, how loss of estate should be computed? What percentage of his earning?
My lord, loss of state is the same calculation as it is done in loss of dependency.
Yes.
But only thing is that out of the total amount, 25% is the total saving of the disease. That amount.
Where is that logic? Any authority which gives that logic that?
My lord, I placed judgment of all Guwahati High Court, my lord.
No, it has not clarified in so many terms. It has only stated that 25% can be. It has referred to a case where loss of estate has been taken to 25% of the total earning of the deceased. Why 25%? Why not what?
So this is a calculation arrived by for calculating loss of state.
Where? On what basis you are saying? Some authority, do you have any authority?
My lord, I'll place the authority tomorrow.
How to compute loss of state?
My lord, I'll place it tomorrow. There's no problem.
Tomorrow,
Just placing judgments. Yes, sir.
in this case, the issue is that accident is not disputed. Death was due to negligence, not disputed. Liability of the insurance company not disputed. Earning was also not disputed.
Yes, yes.
What is disputed is only computation of the assessment of computation of the compensation. On the basis, insurance is saying that this 16 lakhs shown as loss of 16 lakh as shown in the impugned order as pecuniary loss.
Yes.
Insurance company is saying that that is loss, that has to be loss of estate only. But it appears that it is not loss of estate, it is loss of dependency. You are saying that it is not loss of dependency, but it is pecuniary loss to which the claimant is entitled as per Sarla Verma, because Sarla Verma nowhere speaks about loss of dependency.
Loss of estate. My lord, in Sarla Verma, the claim was filed by the widow. And
No,
minor
no.
children. Obviously, they'll fall under dependence. So it was awarded under the head
No,
of.
therefore my queries are to you is because the general understanding is that unless you suffer a loss, the question of compensating you does not arise. Loss has maybe either loss of dependency or loss of estate or loss of something for which you are required to be compensated. So you show me a case where, show me any authority where it is categorically explained and discussed that what is loss of dependency.
Yes.
What is loss of dependency, how it is to be calculated, and what is loss of estate, and what should be the percentage of calculation, how loss of estate is to be calculated, insurance company.
Yes.
You can also answer this query. Tomorrow, we'll continue with this and tomorrow we'll dispose it of. Heard Mr. G. Kato, learned counsel for the appellant. Also heard Mr.
H. Lampu.
H. Lampu,
Yes.
learned counsel for the claimant respondent. Hearing remained inconclusive. Please this matter again on 30 August 2024 as part of
All right. Deeply yours.
this judgment you keep in the record. Otherwise tomorrow again.
Lordship, this is husband and wife, joint petition, Lordship.
Husband, wife, what?
This is a 498.
Quashing?
Yes, question. Covers case under the para 14.
No case is covered case. All husband, wife disputes are.
Yes. Para 13 and 14 of this Lakshmi Narayan matter.
Now you are living together.
Yes.
Yes, Mr. Ete.
Yes, Your Lordship, it's only governed by the Lakshmi Narayan case. It's a matrimonial dispute, Your Lordship, 498A.
Okay. Heard Mr. T. Tapak, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. This application under section 482 of the Constitution of the Code of Criminal Procedure, 1973, has been filed jointly by the petitioners, namely Shri Gabang Pangsa and Srimati Nini Pangsa, who are husband and wife in relationship, for quashing the proceedings of GR case number is not there. GR case,
Here case number is.
charge sheeted case.
Yes, charge sheeted case.
Charge
Year
sheeted.
number 80 of 2015.
GR case number 80.
80 of 2015.
GR case number 80 of 2015, corresponding to Konsa PS case number 35/2015, pending before the Court of Learned. Which court it is pending?
Judicial Magistrate First Class Konsa.
Before the Court of Learned Judicial Magistrate First Class Konsa. Stop. The facts relevant for consideration of the instant criminal petition, in brief, are that on 11 June 2015, the petitioner number 2, Srimati Nini Pansa, had lodged an FIR before the Superintendent of Police, Tirap District, Khonsa, inter alia, alleging that the petitioner number 1, who is her husband, has assaulted her and subjected her to cruelty. On receipt of the said FIR, Konsa PS case number 35/2015 under section 323/498A/494/506 of the Indian Penal Code was registered and investigation was initiated. Ultimately, on completion of the investigation, charge sheet has been laid.
Yes, charge sheet has been laid.
Charge sheet has been laid before the Court of
MFC.
Learned Judicial Magistrate First Class, Konsa. Stop. Learned counsel for the petitioner has submitted
Charge also framed, Your Lordship.
that though charges under what section?
Charge framed under 323, 494 and 498A.
Though the charge under section 323, 498A and
94, Your Lordship.
494
IPC.
of the Indian Penal Code has also been framed against the petitioner number 1. However, in the meanwhile, both the petitioners have amicably settled their dispute and presently residing together or separate?
Yes, together.
And they are presently residing together as husband and wife. Stop. Learned counsel for the petitioner has also submitted that. To that effect, they have also executed a mutual deed of settlement on 17th January 2023. A copy of which is annexed along with this criminal petition as annexure number 4. Stop. Learned counsel for the petitioner has submitted that in view of the settlement arrived at between the parties who are husband and wife in relationship and who are now peacefully having a marital life, comma, there is unlikelihood of the pending criminal case against petitioner number 1 ending in a result of conviction. Stop. And therefore he submits that in view of the settlement arrived at between the parties, the GR case number 80/2015 pending before the Court of London Judicial Magistrate First Class Khonsa may be quashed. Stop. On the other hand, learned additional public prosecutor has also fairly submitted that considering the fact that the parties hereto are husband and wife in relationship and are presently residing together after reaching an amicable settlement, comma, the chances of the GR case number 80/2015 ending in conviction are very bleak, and therefore it would be an abuse of the process of court to continue with the proceedings of GR case number 80/2015. Stop. Learned additional public prosecutor also cites the judgment of Lakshmi Narayan versus judgment of the apex court in the case of Lakshmi Narayan versus, yes, which is the judgment?
State of Madhya Pradesh.
State of Madhya Pradesh.
Lakshmi Narayan,
Reported in
2019,
reported in
para 13 and 14.
2019 5 SCC 688, wherein
Paragraph 13.
the apex court has observed that
Your Lordship, that judgment is produced from I think it's from the Supreme today, but in SCC and Supreme today, SCC, it is para 15.
observed that where the nature of dispute are arising out of matrimonial relationship and where the parties have resolved their entire dispute, the powers section 482 of the Code of Criminal Procedure may be used to quash criminal proceeding in such cases. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. In the instant case, both the parties are husband and wife in relationship, and though the FIR was lodged about 9 years ago, comma, and the case is still pending for trial before the Court of London Judicial Magistrate First Class, Khonsa.
JMFC Khonsa. Tirap.
However, the parties have already reached an amicable settlement between them and are now residing peacefully as husband and wife. Stop. In view of above facts and circumstances, and in light of the observation made by Apex Court in the judgment of, in the case of Lakshmi Narayan versus State of Madhya Pradesh within bracket Supra, this court is of considered opinion that it would be futile to proceed with the prosecution of GR case number 80/2015 as the chances of conviction are very bleak. And as continuation of said case would only amount to be an abuse of process of the court. Stop. In view of above reasons, this criminal petition is allowed and the GR case number 80/2015 arising out of Consa PS case number 35/2015 pending before the Court of Learned Judicial Magistrate First Class Consa against petitioner number 1 Gabang Pansa is hereby quashed.
Deeply obliged.